Yes.
Minute.
Pass out.
Pardon to mention, my lord. 2024 matter.
Pass on.
So the petition will be this month.
Pass on, sir.
My lord, may I submit one thing? My lord, this is a PIL matter. It was mentioned several times, but not getting listed.
Why it is not listed, why? Mentioned several times. Take it. Yes.
My lord, I am in fixing.
Yes.
My lord, one REIT appeal number 3148 by 2024. That simple question is the maintainability of the REIT appeal, because the doctrine of reprobate and under the doctrine of reprobate and approbate, the petitioner has turned on after being failed in the selection process.
Don't consider everything very simple question. I am a complicated man, sir. I will make it more complicated. So, pass on the number on the chat box. We'll consider it. Yes.
Supplement.
My lord, obliged. Deep obliged.
Supplementary list for judgment item number 1, WPC 6233 of 2025.
The petition is dismissed being void of merit, but the circumstances, there shall be no order as because all the eligibility applications stand disposed of.
My lord.
That's as per instruction, I have verified that payment has been made. That's it.
My lord, the last occasion directed the revenue to verify the pre-deposit your lordships.
Yes, have you
Yes, verified. That's it.
deposited?
Yes, deposited.
Prior to
this?
disposal
Yes.
of appeal.
Yes.
So, on that ground, why? Yes.
Yes, closed. Will set aside
My lord.
and that
And remit the matter back to reconsider on merit.
and
My lord.
the appellate authority has touched some merit. He should not have.
Yes.
Once he observes that pre-deposit is not made, he should not have touched the merit, saying that he has not furnished any document. He should not. Anyway, we will set aside and
My lord, physical hearing may kindly be extended to by the Commission of Appeals.
Oh,
no, that appeal will be revived.
Great.
let them take the recourse to law. That's all.
Great.
Because he admits that pre-deposit has been made.
Yes.
So rest,
Yes, call.
Item number 3.
My lord, relating to cancellation of RC, my lord.
Yes. Yes.
Item number 4.
Is the case, my lord, where I have said that this petitioner, in this particular case, my lord, the petitioner was having different GSTIN numbers, my lord. Unfortunately, so far as the Orissa GSTIN number, where he should have been independently assessed for the Orissa operations, the all India figures were taken, even though, my lord, it was reflected in the
That you argued on the other day.
my lords. And my learned friend, lord, he was asked to take instructions in this matter about this.
I have asked the department to give instruction. Till now, I have not received any instruction.
Why?
Not-
Oh no, if they are so reluctant, then what to do?
Lots of without taking my consideration on record, the
Let it
matter
go
may
back.
be remanded back to
That would be the best possible in interest of both the parties. because admittedly all these materials were available in the show cause stage. It was given, my lords, and he records it in his order that these are my stand before the show cause notice stage. But all the same, my lord, he takes the all India figure and he takes a figure so far as 1920 is concerned of another holding company, my lords, which I had shown it on the last occasion.
How much time will you take to get an instruction?
Interest parties.
He's in predicament. Kindly visualize
At least
his predicament.
my prayer would be that it in the interest of both the
No,
parties.
that's true.
If it goes back, my lord, it'll save time for them also.
Next week.
You just write them that this as a last chance we have taken a adjournment, but we can't continue in this. Yes. Yeah.
I
14th,
just pray for some interim
on
protection.
14th,
Sorry.
on 14th we are keeping. Let them take a last chance. The Takeria, the Junior Standing Council submits submits that despite the communication having made to the concerned officer, yet he is unable to receive any instruction. We have our praise and accommodation to enable him to take instruction in the matter. As a last chance, let this matter be listed on 14th. In the meantime, Mr. Kedia will ensure that the instruction is received by him.
Some protection, my lord.
Item note 5.
For some protection, my lord, in this case.
Yes, protection, any action which will be taken will abide by the ultimate decision of his.
May I pray for 15th if your lordship would my conducting counsel, sorry, my lord.
Yes.
Mr. Kedia, if they have not complied.
So instead of 14th, may I just pray for 15th, my lord, sir?
15.
Subject to your lordship's convenience. Oblige me.
Item 5. Item note 5.
Item number 5, my lords. This matter.
Principle of natural justice.
That's, my lords, that's one part. There are some additional developments which I have to bring to your lordships and by way of an additional affidavit. May I pray for next week, my lords? Any date convenient, my lords?
Yes. The court submits that in the meantime, subsequent events have happened, which have the material bearings on the points raised in the instant writ petition, and therefore those are required to be brought on record.
Can I raise some preliminary objection?
What for?
Your Lordship, here, the orders in these three cases, the orders have been passed in 2023 and the writ have been filed in 2025. That is number one. Number two, here your Lordship.
May I just file an affidavit? My learned friend is
Subsequent event has come, and if it gives rise.
And your lordship, in the first case, he fixes up with great respect to your learned friend. In the first case, he fixes the date of hearing to 6th, passes the order in 5th.
Due to,
and it's on the record itself. If your lordship would my learned friend is very vociferous, my lord.
Due to
Annexure 3, he fixes it at 6th.
No, I understand. So
due to the
he is a cancer patient. He was under treatment until he's
let the additional affidavit be filed by 12th or 13th.
13th, my lord.
By 13th. The copy whereof, semicolon, the copy whereof will be served upon Mr. Mishra in advance.
I'll do
it. Put up the matter on 14, 15.
14th or 15th, whichever date is convenient.
14, you have a problem in other matters, that's why.
That matter, Lord. That's coming on 15th. Let us come on 14th, Lord. So that both the matters don't
both the matters would come on 14.
Okay.
So why?
Oblige me.
My learned matter also 14. Right. Communicate. You are appearing in the
some empathy should be shown, my lords, to a genuine case, my lord.
Empathy, sympathy, compassion, everything.
My lords. The cold letters of law, my lord, should not be applied in all cases.
Subsequent development, only these cases become
all points, including the point relating to the maintainability / entertainability of the writ petition are kept open.
Yes.
Item number 6. Item 6.
The revocation
Your Lordship.
Yes, well, it's GST RC.
This is a revocation.
Yes, well,
So cancellation. Yes, next.
Item number 7.
Yes. Here I challenge the annexure 1 and 2, that is so-called notice and the adjudication order. That was in, they have disallowed my input tax credit of subsequent cancellation of RC of the supplier.
Subsequent.
Cancellation of the RC, registration certificate.
Yeah, no, I understand.
So registration certificate has been cancelled in 1920. My transaction is 17 and 18.
Similar matter is also there.
No, Your Lordship, that is not the issue here. Let
It's
my
not the
learned
issue.
senior,
Just
that is not,
Raising an issue.
not basing on cancellation anywhere, not anywhere in the order.
He is raising an issue.
I'm not
Anywhere,
going to 74.
anywhere in the order.
Mr.
Kindly have a glance.
If suppose that fact has not been stated by your assessing officer anywhere,
Your Lordship.
but assessing authority should have exercised his power and access the net
Here,
to see
Your Lordship,
that supplier's registration
Your Lordship.
was
Here-
valid during the period of
Here the assessment has not been done due to cancellation of RC, Your Lordship. Here, the assessment has been done basing on investigation report. Your Lordship, the entire assessment, Your Lordship, let my learned senior place. The entire assessment, how the ingredient of 74 has been fulfilled, how the investigation
No,
has
I
been done.
understand. The conclusion is that there has been
Non-existent,
input tax credit by reason of fraud
Your Lordship,
that he has quoted it.
Your Lordship.
Now he says that while doing so, this fraud, they might have taken into consideration the cancellation which was done subsequent to the transaction.
Here,
What their contention
Right.
is, and if it is one of the consideration, then definitely.
here the allegation is that
My lord,
the fraudulently he has done the invoice. Your Lordship may
It
kindly,
is a serious issue,
Your
no
Lordship.
doubt about it.
so this is appealable because all the factual aspects are there. Your Lordship may kindly turn to page 43.
Anyhow, let him first place.
Your Lordship.
What is
Your
the
Lordship.
reason?
Your Lordship.
my lord, kindly have a glance too. They are shouting always about the portal. They have only relied on the tax evaluation report, that is annexure 6. That is at page 76.
Yes.
Apart from that, another dispute is that the report is submitted.
Non-existent, you want the non-existent at the registered address.
No, another here is that the report is submitted by the deputy commissioner, and this focus is relying on the basis of that the state tax officer has.
Because one after the other. You first convince us that this supplier's registration pursuant to a letter received by the authority concerned in 2020,
My lord,
as it seems from the assessment order,
kindly have a glance to our registration certificate.
44.
No, I have downloaded the.
Come to page 44. This may be the issue which you are now raising on. In 33 it began, the undersigned has enough reasons to believe that the invoices involved in such transaction is bogus and not in accordance with section 31 of the Act, are issued just to pass on bogus ITC. And thereafter, in 44, he refers to a letter. The letter having reference number so and so, dated 21/7/2020, clearly indicates that the said supplier is
It's a
not
non-existent entity.
Invite. So, if that is non-existing entity, as per the assessing authority, you have to show that they were existent and their registration was valid, and you had the genuine transaction with him during the
During that relevant period.
transaction period.
Well,
So
kindly,
this is how you have to establish your case.
kindly have a glance to page
If you
101.
dispute in
Page
this,
101,
then we will not.
101.
my lord. That I have downloaded from the portal, registration of the supplier.
10.
1,
So your transaction period is 17/18.
18, 19.
Okay.
Where is 101? Yes.
last GST cancelled suo moto effective from 110
The Shiv Shankar Kumar. Street name is Pawan Sat.
Pawansu Enterprise. And
Enterprise.
RC has been cancelled suo moto.
Effective date of registration is 1/7/2017. Proprietorship concern.
My lord.
Cancelled.
Cancelled suo moto with effect from 1/10/2019.
19.
So
Yes, so what about the
Prima facie-
transaction?
My transaction is 1718. My transaction is 1718.
Here, your lordship.
And all the transaction he has reflected in the 2A and 3B. He has paid the tax also.
Where do I get it?
That, my lord, you can get in 103. 103 filing of detail of 3B. Up to
Yes.
June, he has filed, June 2019, he has paid the tax.
File, yes.
And also filed the return.
So 3B has come in the year 2019. 3B see, from the very beginning, 3B was not there,
Your lordship.
isn't it?
Your lordship.
Am I correct?
Your lordship.
So
What
when
day?
has it come?
That is not the issue here. Your lordship may kindly turn to page 50. Page
50?
50, your lordship, 50.
Prior to that 2A, kindly have a glance to 127. 127. That is 2A. That is reflected in my portal. Kindly have a glance. That invoice number is there. And filing of GST 1 and 3B. That is yes, YY. So after that, I have taken the credit.
That was during 2017.
That is what 2007.
His portal was showing that his registration was valid.
Because he has paid the tax.
That means he was
Because
existing.
it was with effect from 1st of October 2019.
My lord.
So these are the portals. Yes, the status is yes, GST 3B.
And this is totally covered by our own High Court judgment also.
Please, we will also hear the objection of Mr. Misra. So all the transactions are between 17 and 18.
Certainly. They have not cross-verified my portal. They are only relying on the fraud case report of the supplier. They are initiating the proceeding. Because everything is in the portal. They are shouting portal, but in this case, they are not cross-verifying the portal with my documents. And all these documents are filed at the time of so-called reply.
So third party material. The investigation report of the enforcement unit is itself baseless, as they have declared a supplier so and so as non-existing business entity just on the basis of a visit to its registered place of business where he is not found. That is what his explanation.
The brief facts which you have stated in your order, that shows that this particular the transactions, the invoices which he has relied upon to avail the input tax credit, those were found that that it is a bogus one or a fake one, fake in nature. Why you say fake in nature? Because the particular the proprietor or a partnership concern does not find place at the place of business. They were not found. So you also said that there may not be an actual supply of the goods. I understand. This is what really you say. And then you say that it is not. Now question is,
Not only
if
that.
it is a non-existent entity, let us proceed. That, as you said, he has shown in page 126, 127 that this particular entity during a relevant period, say 2019, submitted the returns which you have accepted. The system has accepted and everything was there. It is not that he can be said to be a non-existent entity. Question is, it's again a question of fact whether there was an actual supply of a goods or there was a clandestine arrangement between him and the gentleman. So just to issue invoices to have that particular
That
IPT.
invoice also.
That is what I'm saying. I was coming into that. If it is
Mr.
a
Mr.
clandestine, then there must be that must be verified
My
by several records which is maintained by him.
Your Lordship. Your Lordship, a detail, my lord,
The stock register, the utilization, if it is a raw material, then the utilization of the raw material for manufacturing the finished goods, we don't know. Or if he's a trader, then at least the stock register would show that what has come and what he has sold.
Your Lordship. Your Lordship, the detailed investigation.
Mr. Mishra, come to page 77. That is your enforcement report.
Your Lordship,
Come to that page.
this is the detailed report.
Please come to page 77. That is enforcement report.
Your Lordship,
Please.
that
come
is a
to-
part of reinforcement. The entire report is here.
That is the tax evasion report basing on which his assessment has been framed.
Your Lordship, this
You
is
have supplied him this copy?
the entire has been supplied, but only 2 pages have been
Come
enclosed.
to This page, sir, 77.
My lord.
Place the last paragraph.
As the so-called supplier is non-existent business entity, the amount of input tax credit available from it by the taxable person on the report is fake and without actual receipt of the good. As per section 16, section 2 of the OGST 17, no registered person shall be entitled to the credit of an input tax credit in respect of any supply of goods or services or both by him unless he has received the goods or service both. In this case, as the supplying business is non-existent, the amount of input
This
tax
is what
credit
is you proceeded on the basis of a non-existent at a particular date.
after
What is his attribution to this?
Your Lordship. After that,
How far he has
Your Lordship may kindly turn to page 50.
the attribution to this transaction? There is no allegation.
Your Lordship, page 50, how the invoices have been done in fraudulent way. Your Lordship, page 50, Your Lordship, the finding of the
The
assessing officer.
report clinches, which you have given it to.
Total investigation report is there. Your Lordship, I may be permitted to
Where
supply.
is- They have supplied you.
Only
Entire
two,
investigation report.
2 page report.
So,
Your Lordship, the
So-
taxpayer may
so-
kindly look into the.
so why should we? If you have not supplied to him.
That's supplied, Your Lordship. As
Where?
per my instruction
Where?
that in course of,
Many
in
instructions.
course of Your Lordship may kindly pays that has been supplied reflected at page
Mr.
36.
Department has not yet changed.
Your Lordship,
Right from Bhushan, Vedanta,
Your Lordship, page 50.
Sterlite.
For a moment, page 50. Not only this fraud, not only this ground, how the has been done, page 50, Your Lordship may kindly turn to paragraph 1, Your Lordship. Shall I place, Your Lordship? The taxpayer has argued the investigation report of enforcement is itself baseless as it has been declared as non-existent just on the basis of a visit. To the further, the taxpayer alleged that said invoice has been made making further inquiry so and so. However, it is to mention here that the said it has been prepared after thorough verification of the business premises of the said supplier. Moreover, summon was issued under section 70 of the instant supplier which was written unserved. Further, a field visit conducted and a statement of Janaki Prajapati was recorded. In my report, all these things are there. Further, a statement was recorded from Kamal Sahu, who was residing just beside principal place. Your Lordship may kindly page paragraph 2. The taxpayer, as he has physically received the goods, again he has furnished the tax invoices and corresponding e-waybill. Further, he has submitted documentary evidences. It is mentioned that so and so to avail ITC primarily requirement to have valid genuine. However, in the instant case, section
Very
16.
interesting facts you have furnished the reply which you have recorded. Very interesting facts have come. You have arrived at this conclusion because somebody says, I do not know this company. I do not know who is the gentleman. You immediately jump to the conclusion that the signature is fake.
Page 50.
Everything. The other part of the episode is that particular entity, the partnership concern, was allotted a GST number. It is an admitted fact. You can't deny. It is also undeniable that that entity submitted the return 3B. It was submitted. All the returns were submitted up to 2019. Thereafter, you suo moto, it was cancelled. So at least up to 2019, and when the raid was conducted,
You're right.
when this was done.
2020, Your Lordship.
So a person who has discontinued the business,
Your Lordship, what happened?
he will not be found at the
Your Lordship,
business.
it is a very sorry state of affairs so far as the
but
GST Act is
the
concerned.
difficulty is, I understand what you are thinking about the department, but on the black and white situation, look at it. Had it been that he has given that particular number, never filed the return, proceeding was continuing against him, he was evading the tax, everything is there. Yes, clandestinely he is making a transaction. We appreciate, yes.
Your Lordship,
That is still, there was nothing.
Your Lordship, I bow down. GST Act has been formed in such a way, it is a very sorry state of affairs, Your Lordship. So far as Rule 9, Your Lordship, GST Act, granting of registration, Your Lordship. Prior to that, indirect taxes, Your Lordship, for a moment.
No, I understand.
Indirect taxes, the registration, there should be an inquiry. In GST Act, Your Lordship, once you have to put the mobile number and an email number, so automatically in one day,
Catch hold of, sir.
let me, Your Lordship.
Whom to catch hold of?
How the fraud, Your Lordship,
The
in
fraud,
this-
I understand.
Your Lordship cannot find
Sir,
a single document.
Up to 2019, that was the transaction of 2017. So
Correct.
it is not that he was not uploading from 2017.
Your Lordship,
No.
in the portal, in the system, in the document.
Oh,
It's just-
please, I understand where you are heading.
Your Lordship,
But the difficulty is that he must be uploading those, the return
Your Lordship,
on the portal
Your
since
Lordship.
2015, 16, 17, 18, 19.
Your Lordship.
It's no difficulty. You must be assessing it, you must be verifying it, you must be
My lord.
scrutinizing
My
those. And for 2017 and 18, there was nothing which came against his supplier.
My lord.
And if all the invoices which he has issued, everything has been taken by the department,
Your Lordship.
can he now raise a dispute with regard to those transactions?
Your Lordship, what happened?
Any subsequent transactions, I can appreciate,
Your Lordship,
these are all done clandestinely, but for that period,
I
2017.
bow down, Your Lordship, but the frauds have been committed in such a way, Your Lordship, nobody, even it is. That's some verification, Your Lordship, because how the fraud is going. Everything, Your Lordship cannot find a single error in the document, Your Lordship. How the fraud is going on. Your Lordship might have remembered 100 crore, 200 crore, 1000 crore. This is the fraud, this type of fraud. Your Lordship, everything is genuine. Your Lordship, suppose a company, a existing company at Chhattisgarh, Your Lordship, a manufacturing unit, has to make some
Not have to, because I came from a place, you know.
See, Your Lordship,
Here I have particular philosophy.
Your Lordship, all these are factual aspect, Your Lordship, allegations. Required to verify. Your Lordship, let him file appeal. It is well within the time, Your Lordship. 74. Your Lordship, it is a genuine case. Your Lordship, I can prove it is a genuine case of
I
fraud.
want to know whether you have simultaneously
My lord,
checked up his stock position. Simultaneously.
my lord,
Place a contemporaneous document that you have checked up his stock was not inflated.
when it is found, Your Lordship,
When you say that such and such supply is not made to the recipient, so you should have checked up his recipient.
if at all, it required verification. I don't deny, Your
I am
Lordship.
existing. 11 business.
See, you are existing.
So
It required verification.
has,
So let the appellate freedom of assessment.
In a common commercial aspects, what is expected? If he's a trader, I do not know whether he's a
A trader.
trader or a manufacturer.
Trader.
If he's a trader, if he purchase of goods from somebody who is a intending supplier and have also paid the GST, then those goods which he is a recipient has to be shown in the stock. And then when he is again reselling those would also be reflected in the stock register, that how much has gone. If you say that there was no passing of the goods, because I find from the brief of facts, you say it's a fake one and there was no actual goods which passed on,
Your Lordship.
then he can't show it in a register. If he show it clandestinely, and then sell it, there is no difficulty of a further cross verification from his purchaser. You could have done.
Let's see.
If you wanted to unearn, then you could go by a chain. Is known because he has said that I have sold a portion of this goods or the entire goods to this gentleman. Raised in invoices, shown the stock that it has gone down. I have already sold, it has gone. If you know that is also a registered dealer. If you know,
All are registered dealer. All are registered dealer.
Immediately,
The purchase from all registered dealer has been nullified by the registered dealer.
there's nothing, goods never passed. You'll have to then.
so far as my
prove it.
memory goes,
Well,
I think under GST, this particular supplier's
My lord.
case has been decided.
Your Lordship, that case, no inquiry has been made. In that case, except cancellation, no other registered, no other grounds have been, no inquiry has been made. Only registration.
Calcutta High Court relying this Odisha judgment.
Your Lordship, I pray let him file appeal because
When
it is,
we have a judgment at a 0 kilometer. Why travel to 400 kilometers? It is only because I traveled 400 kilometers.
But this is Odisha or Pune High Court judgment. Kindly have a glance.
Cite it a 0 kilometer judgment.
Your Lordship, it is a fit case for appeal. Because appellate authority is,
Notice.
Your Lordship,
Fit case for notice.
as Your Lordship pleases.
Inviting your acumen, how you will justify the assessment order vis-a-vis tax
Your Lordship,
report which you have
Your Lordship, in
supplied.
2017, I am arguing all these fraud cases so far as
We are asking-
criminal cases.
Where Ansel will cancel.
How much fraud has been done? Your Lordship,
We are
Sir,
deciding.
difficulty is that fraud, if you want to really establish, then there should be a very incriminating materials which you should unearth by doing this.
So it is quasi-criminal in nature when 74 is concerned. If had it been 73,
justified case, Your Lordship, what I pray, it is a justified case under section 74.
so far as he is
So,
concerned,
because Your Lordship yesterday has gone through that notification, so far as the investigation, Your Lordship. Basically, on investigation, if assessment has been done, it is
Sir.
274.
sir, in a transaction, if a recipient will not believe the portal which is shown, the supplier's registration is
Your
valid
Lordship,
on
paragraph
the
6.
transaction.
Paragraph 6, Your Lordship. No inquiry has been done.
Yes.
Yes, interview done.
No inquiry has been done, only cancellation.
On the basis of report, cancel has.
No, basing on cancellation, the assessment has been done.
They have submitted the report.
Basing on assessment, basing on cancel, I have come to. I was the admin counsel.
Same supplier.
Here, let's see.
Same supply.
Paragraph 6 of that order. Here, let's see.
There may be a strong presumption, but it must be a statutory presumption. In the
Same advocate, same set of advocate.
No, same set of fact. No,
Same
assessment.
set of advocates.
same set of advocates.
Yes.
Smile.
They are no, they are only.
Pawan suit. Enterprise.
Same allegation. We were proposing to issue notice subject to payment of 50% of tax.
You show your bona fide that you have a.
Then why
We'll
else
see
go-
to it, and if it appears,
Then go
Or
for,
else go to appeal. Or else go to.
because my submission
Or
is
else go to appeal.
he has not verified my documents, whatever I filed.
sir, we will hear out. If we have to take a dissenting view, we know if we have to then refer the matter to a larger bench as well. No difficulty.
Verify all
If you
these things,
take-
cross-verify, because I have filed all the documents.
Now,
This is yours, sir.
now interim order, if you want to give, we can put any person on terms. We can't grant a blanket interim order without putting a party to a
This is the order
terms.
ballot hasn't passed. Same.
Yes. We'll say that interim order is as the court may deem.
In similar
fit and
matter, in
proper.
RC cancellation, this is the order.
No difficulty, but we show your bona fide and deposit this much of it.
There is that RC cancellation.
No, that's true, but that is a different issue. The
No,
facts
but
are different.
RC
The facts are
cancelled.
different. No,
My,
it is not a
my
case.
RC is subsequently,
Sir.
retrospectively.
The question is, it was a case where only the cancellation was the issue.
No,
There is a case, there
transaction has been
was,
disallowed.
no, there is a case, there is a very serious issue that this particular, the entity, that particular enterprise, its existence is not only in doubt, but there has not been any genuine transactions which has been entered into.
My
All
lord,
these things have to be.
at the time of adjudication, I have filed
So
all
we
the
can-
invoices.
We find a prima facie case having made out, and there is no fetter on the part of the court to put the party to terms. So we can put you on terms. We'll grant you a no coercive stay, no nothing.
And he, apart from that, the report is submitted by the deputy commissioner. Still, under the
PSI case,
it is influence.
sir, it is a prima facie case.
Is a authority lower,
These are
these
all the good prima facie case to be gone into.
then I will go for appeal.
Get full.
Okay. Immediately over. And if it is proceeded. You will not do waste time more.
We wanted to go for an appeal. That's why. We wanted to go for it.
Then,
Because all the document has to be verified. So,
seventh. It is the order of adjustment. What is the annex?
annexure 2.
Annexure 2. Order dated 4/2/2023. You can see order dated 2023. Passed under section 74 of the GST GST Act. The present restriction has been filed. It is submitted by Sri P.K. Harish. The entire assessment is based on allegation of suppliers non-existence being found during the course of the investigation. And consequent upon the same, the input tax credit claimed by the petitioner during the period March July 2017 to March 2018 has been disallowed, and accordingly demand has been placed. Mr. Suril Mishra, standing counsel for the GST department, CT and GST organization. So, vehemently approached for entertaining this restriction
In view of
on the ground that effective and efficacious alternative remedy is provided by the statute. At this stage, Sri P.K. Haricharan, advocate for the petitioner, seeks withdrawal of the restriction to approach to avail the
appellate forum.
appellate forum as provided in the CGST stroke GST. Mr. Chaudhary Safiq, Mr. Senior standing counsel for the CGST organization. So, CGST, CX and customs. CGST, CX and customs. Consider that the petitioner could very well be relegated to avail opportunity of alternative remedy. Faced with such situation, this court grants liberty to the petitioner to approach appropriate authority as available under the CGST stroke of the SPR. With the FSC, in such the restriction stands disclosed.
Connected also.
Connected methods of similar.
Well, it has been filed in time, within time.
Yes, yes.
with matter is same for another period.
Similar,
Similar, another period.
18, 19.
another period.
Other period.
1920 का तो period का देखिए तो allegation same.
Same.
Great, you.
Item number 8.
May I please start?
My lord, I am for the respondent.
Is my lord, the regulars file this other tax arising out of the order of the cess tax by annexure 1. Lord, here the issue is Lord Notshell. Lord, the tribunal lordship know the creature of the statute, and the tribunal is directed to pay the interest on the late payment of the dues which is deposited without having any authoritative law, without Lord, any statute, is treated to be as a compensatory interest, which has been arising, Lord, the referring the Supreme Court judgment. On that is a separate, altogether separate, and the tribunal, in my Lord understanding, Lord, has no authority to direct the department to pay the compensatory interest, because the statute is clearly provided how to deal with the interest part. So, Lordship, this is the, in this case, your Lordship kindly, Lord, in nutshell, kindly, Lord, the improving order, internal page 69.
Appellate.
Is I am for the applicant. Revenue is the
Department.
department.
The appeal filed by
Revenue.
revenue was
Custom.
rejected.
Yes, Lord, no. Lord, the, yes, Lord, the appeal is filed by the opponent, Lord, the Vedanta. It has been allowed in favor of the Vedanta, directing
No. It says which order is under challenge?
annexure 1, your Lordship.
Oh,
Is
I was looking at the another. This is no. Annexure 1 is the
Appellate orders. Appellate presence.
cess tax order.
this one.
Lord, slightly, Lord,
Somebody else.
previous date order, Lord.
Somebody else.
Previous order is not slightly.
Member.
Oh,
Oh, I skipped because of that name. I just thought that earlier order must be relied on.
so only issue is, Lord, in this case, whether the tribunal is authority and power to direct the department to with interest. Even if, Lord, the statute is provide the procedure.
If you unreasonably and without any statutory right having created withheld the amount, then is he not entitled to a
No,
compensation?
that is not exactly, that is not a case, your Lords. That is exactly not a, kindly see, Lord.
If his liability was not there,
No. Here,
no authority to direct that payment.
no, here is a case,
Or
Lord.
unreasonably, you continue withholding the money.
No, not exactly, that is
So-
not a case. That is not a case, your Lords.
Then
I'll
what is the
satisfy.
case?
Here is a case, Lord, he is not pay the Lord, custom duty and self-assessed. These custom duty paid sales by cargo, Lord. Thereafter, Lord, he is requested for the provisional assessment under section 18. So this provisional assessment is delayed. That is what the tribunal said. It is delayed. But Lord, when Lord, the appeal and the order has been raised with finality, then he applied for the refund, and the refund is to pay within 3 months of date of application. Lord, we have paid the refund within that 3 months as per the statute 27 capital M. Lord. Now the tribunal come to hold that as there is the date of deposit, you have to pay the interest 12%. So that is the case, Lord, whether the power is with the tribunal, go beyond this time, kindly see 27 capital of the act, Lord, customer. interest on delayed refund, Lord. I have quoted me, Lord, in appeal, Mama, kindly see, Lord.
First thing is, when a right to refund
Yes.
accrues,
Yes.
one has to understand.
Yes.
And the delay in the interest on a delayed payment will definitely arrive on the day when the right to refund accrues.
Yes, Lord.
No, I understand. So here in this case, when this right accrues,
Right accused, Lord, and the date of passing Lord, passing
when
order.
it's a determination under section 18, as you say,
Yes.
when it is done,
After
towards the 18,
yes, your Lordship see.
towards the 18.
Yes, madam. Before that, 18, your Lordship sees 17, because this is the assessment duty. 18 is assessment,
No,
not
it's a self-assessment of the
Yes.
goods. There's no difficulty.
Yes.
When 18 dispute,
yes.
show us.
Then Millard comes the provisional assessment.
Yes.
So notwithstanding anything, contained is that without prejudice to the provisional.
First condition is unable to make a self-assessment and request in writing for
Yes.
the proper officer.
Proper assessment where the proper deem it necessary.
Whatever.
Yes.
May direct the duty leviable. We assess provisionally if the importer
Yes.
furnishes such security as such and such.
That order has been passed, Millard. Then Millard, the revenue. After the Millard adjudication order on 8/4/2022, we have paid we have refunded the interest, refunded the duty as per their application, Lord.
They have to make application for.
Yes, that is what the contemplated under the Act, Millard. 27 capital A.
My lords,
Capital A.
Just like OST.
Yes. On application.
Section 18(1), which is being referred, my lord.
Just a minute, sir. Appeal has not yet been admitted. Please wait.
My lords, it's the amended provision which is being referred.
You need not, sir. He's an appellate. We'll hear you. Don't worry. Yes, sir. So 27 is attracted in
Yes.
case when there is a adjudication or an application made under section 27.
Yes. And if it is not
Now-
paid within
now-
that time,
Now it is section 18 when he wanted that I am unable to make a self-assessment. Please make a provisional assessment. If the provisional assessment is made and then it is paid on the basis of those provisional assessment of a duty, and
Yes.
ultimately the final assessment indicates that is an excess, then the refund has to be made.
so now, my lord, it is carried to the appeal. And as per the appeal order, my lord,
Let's see. Let's see, 18(4).
Omkarmal Agrawal.
sorry,
Omkarmal Agrawal.
yes,
Full bench of this court.
yes,
No, there are two aspects of the matter. 27A gets attracted because of section 18(4).
no, my lord, thereafter, no, 27.
There are two things. When you talk about, then I am against your submissions.
Sorry, my lord, I'm not able to.
Then I am against. If you take that, then I am admitting it and against you. If an adjudication is under section 18, then in that event, at the time of final order that is to be passed, at least see the dichotomy which you are now making an argument. By virtue of section 18, adjudication, final adjudication, assessment of the duty.
Yes.
If the excess amount is there, then you are bound to refund that excess amount. And subsection 2 of section 18 also clearly stipulates
Yes.
that this amount has to be paid
Yes.
within what time?
Yes.
Indicates.
Yes.
If you do not make the payments, suppose, then section 27 says that you can make an application within 1 year, limitation period is given. Interesting. You are holding an excess amount, withholding it without any authority, yet you are just anticipating whether anybody would approach under section 27 within 1 year. Suppose if it does not appear within 1 year, I will eat up the money. That's not the object of a sovereign.
Absolutely correct, Lord.
It's not an object.
Absolutely correct.
Both sections operates in a different field. Section 18 talks about the assessment.
Yes.
And 27 does not talk about the assessment.
Correct.
It is where it appears that the excess amount has been paid, then one can apply for refund or an adjustment, whatever.
Yes.
And the period of limitation is provided under section 27. Once the subsection 2, the order under subsection 2 of section 27 is passed, 27A is getting attracted. Explanation there is that if those orders are passed by the appellate forum, tribunal, then in that event, that would be the date for refund construed. But one has to understand that if the order is of such nature passed by the tribunal, for the first time upsetting all the orders of the authorities and directed the refund, then it would accrue from that date.
But I'm slightly not.
If continuously the order is affirmed even up to the tribunal. You can't take advantage of the last order of the tribunal to be a starting point.
No, not tribunal.
Then it will come to a
No,
original order.
Sorry, my lord, we are not. No.
It will
My lord,
go back.
we are not paid the amount of tribunal order. We are paid the amount after the first appeal order. Your lordship, I am slightly not
Sir,
placing the properly.
Sir, there are two aspects of the matter.
Yes.
I tell you. One has to, when you come to section 27A explanation,
Yes.
it says where any order, you have to construe, where
Yes.
any order of refund
Yes.
is made.
Yes, made.
So order of refund has to be made.
Correct.
Pass.
Yes.
By whom? Either by a commissioner appeals, appellate tribunal, national tax tribunal, or any court against an order of the such and such, such and
Correct.
such.
Correct.
So it is the first time the order of refund has to be passed.
Yes.
If it is passed earlier, and then you have approached the tribunals, appeals and all everything, and those orders have been affirmed, you can't take advantage of the last order of.
Your lordship is correctly, my lord. Your lordship is absolutely correct, but fact is slightly different, my lord. Self-assessment made thereafter when adjudication order passed. Then, my lord, we have not accepted. We have passed the order against the assessee, my lord. Then he came up with the my lord appeal, and the appeal may refund flow. We have paid that amount. Then is my lord file a case that to my lord to seek interest.
The appellate court order.
Yes, we have paid.
Within 3 months, you have paid.
Yes, without that period. That is what my case, my lord. I'm sorry, my lord. I'm not able to place the case properly, my lord.
No. When he challenged the order of the appellate forum and the lost it.
After having got the relief, it again went up to.
Yes,
appellate tribunal.
we have passed the adjudic order, then he come up the appeal, and as for the appellate order, the refund flow, we paid the refund as within time limit. Then he will not file a case for the interest. That interest will not we have rejected. They go for the tribunal. Tribunal says will not date of the first sale percent you to pay the interest 12%. Compensated not word is not given there. His tribunal beyond the scope of the
What
act.
is the statutory interest?
Statutory interest will not 6%. 6%.
Ranging between 5 or 6% to 30%.
No, that point, no, that is not been, it is not 2000.
No, I'm looking at the act and then
No, my lord,
something about.
Basing on 27A, my lord, this notification number 75.
It says that.
My lord, 5%,
Not below 5%.
not below the section, that's only paid the apply interest rate, not below than 5%.
By central government by notification.
Yes, that notification,
Between 5 to 30.
that notification 2022, my lord, 6%.
Notification.
The act says between 5 to 30. So this has been amended.
Yes, this notification is issued, not.
Something.
Subject to the.
By
Yes, yes.
central government
Correct.
notification, they have. Where is that notification?
Yes, I'm just.
That is relevant to this.
Yes, Lord.
period.
Thereafter, there is no such amendment, 2002, my lord.
You wanted to say that whether a subsequent proceeding for interest lies.
Interest, my lord, interest is
You
lies.
say that he thereafter make a claim of an interest.
Yes. If my lord is
And you
not.
have already paid. When
Yes.
you have already paid.
Basing on
this
their
is the
application.
Actual amount.
Yes,
This is.
yes.
So the question is whether for the purpose of an interest, can he initiate proceeding under section 18 or under section 27 for interest component only?
Interest 27 capital A, my lord.
Sorry?
Interest has to pay on the 27A. There is no scope of so far as 18 is not applicable. 18 is for assessment. Assessment completed, refund flow, we paid the interest as per their application. Then in the challenge, you pay me the interest on the date of deposit. That is what challenge carried to the tribunal. Tribunal say you pay the interest date of self-assessment. Without any order, department will not pay any interest. Rightly or wrongly, there must be order.
The central government has fixed that.
6%. So how can it 12%? And 12% based on what reason?
So you are happy with the 6%?
No, I am just placing how error has been committed by tribunal to fix the 12% without any basis. That is what my submission. My submission is, my lord, if there is the act is provided for any mechanism, we have to follow that mechanism, and tribunal also creature of statute, my lord. So Lordship has formulated a question of lord to answer this question.
Absolutely. We have a doubt.
Let us hear.
Yes, what do you say? Your turn. Tell us.
My lords, there are certain specific facts which I need to lay down. My lords, the period involved here is of 2008. The shipping bill was filed in 2008. At that time, the provision of provisional assessment under Section 18 was different because it got amended in 2011. The provision which was read out by my learned friend is the provision which is applicable from 2011. My lords, if my lords may see the provision as applicable prior to 2011, Section 18(1).
Yes,
In the footnote.
we have.
It says that notwithstanding anything contained in this act, but without prejudice to the provisions contained in Section 46, where the proper officer is satisfied that an importer or exporter is unable to produce any document or furnish any information necessary for the assessment of duty on the imported goods or the export goods, as the case may be, or where the proper officer deems it necessary to subject any imported goods or export goods to chemical or any other test for the purpose of assessment. My lords, there was no concept of self-assessment prior to 2011.
Yes.
In 2008, be it provisional assessment or final assessment was to be done by the department itself. Every shipping bill was to be assessed by the department. There was no question of any self-assessment. Now, my lords, as per the assessment done by the department, I paid export duty of rupees 300 per metric ton, whereas the actual export duty which was payable was only rupees 50 per metric ton. My lords, this was a provisional assessment which was done. And this provisional assessment was done in 2008. My lords, in 2009, I've been requesting the department to finalize my assessment. I've given all the test reports, everything. They have stretched the matter till 14 years. My lords, till 14 years, no assessments were done, finalization of assessments. My lords, they've kept the money, excess money which I had paid for a period of 14 years for no reasons whatsoever. And despite that, they are not ready to compensate me the interest. My lords, the amount which was there has a value of time. My lords, after 14 years, it has no value. My lords, taking all these facts into the consideration, all these undisputed facts which were not disputed by the department at any level, my lords, the tribunal has held that there was an inordinate delay in finalization of assessment due to the fault of the department. My lords, basis this factual finding, they have applied the settled position in law. My lords, the settled position in law is that the finalization of assessment has to be mandatorily done within 6 months. It has to be done within 6 months, and there are decisions which have been relied upon by the Honorable Tribunal in this case to say that this was to be done within 6 months. And instead of doing it in 6 months, they have taken 14 long years. My lords, on that basis, they have come to the conclusion that on the basis of equity and justice, interest is payable to me. And my lords, insofar as power of tribunal is concerned, insofar as power of tribunal to grant interest is concerned, they have the inherent powers which has been very well held by various decisions of the Honorable High Court.
Yes, no, I give it between 6 months, but it seems that the judicial order is has to be one design. Let her silent. The act is silent. If there is a decision, where is that order which says that within 6 months you have to complete it? Because what we notice is that so far as the subsection 4 of section 18 is concerned, it was very well there in existence on the day when this right accrued.
My lord, the 6 months
about anything else.
My lord, the 6 months period is coming from the customs instruction, which is binding on the department.
Show us, sir.
My lords, may refer to
Any judicial recognition?
Yes, my lords. The decision of Honorable Jharkhand High Court in the case of
Please show us, there is no difficulty. If it is a mandate, there is no
my lord,
problem.
is mandate and decision of Honorable Jharkhand High Court in the compilation which my learned friend must have submitted.
Yes.
It's at serial number 49. My lord, Bihar Foundry and Castings Limited versus Union of India. Para number 18. It starts from page number 49. My lords, para 18 is at page number 56. My lords, may I read out?
Please get me 56. Para 18 is not a, it's a reposition of, I think
My lords, para 18 refers to the CBIC Manual of Instructions. My lords are there at page number 56 of my compilation.
Just 1 minute. Yes, 6 months. The case of case was. Yes.
My lords, para 18, 19, 21, and 22.
Para,
18, 19, 21, and 22.
yes.
My lords, this decision has been referred by the Honorable Tribunal, and following this decision, they have held that since the assessment was to be done within a period of 6 months, but they have taken a period of 14 years for which they have not given any reasons whatsoever. My lords may see the clear factual findings which are there in the tribunal order. My lords may see page number 74 of the appeal file.
Yes, what do you say? This is what a case similar to this. No, it was a case of there was a delay of 10 years, and this here is a delay of 14 years. So that case was more on a stronger footing than this one. And this was held, and there was a departmental, the instruction, which has been found to have a statutory flavor.
Yes.
And this departmental instruction is issued is instructed in Chapter 7 of the Provisional Assessment of the CBIC Manual of the Instruction, which was issued in exercise of power under Section 151A of the Customs Act.
Which is
So it has.
binding.
It's binding.
Yes, no.
And it says that the provisional assessment are expected to be finalized expeditiously well within 6 months.
Yes.
However, then the exception was given in that case also from the date of the last consignment. 6 months was given.
Yes, Milord, this order was passed, Milord, so far the order of washing the order.
Where is your date set?
Yes, Milord, the date
Where
is
original assessment was undertaken when?
Provisional assessment,
so that isn't put in the internal order, internal page
Sir,
69.
there was a delay of 14 years in completing.
Yes,
That you are not denying.
no, Milord.
You are also not denying that he is entitled to a refund. That amount was an excess.
Date of
Paid-
order, date of order, date of order.
Sir, there are two. I understand. Date of order is 14 years after he was harping and claiming no difficulty. I understand. You have construed it from the date of the order. I am paying within 3 months.
Yes.
Well within this. Now the question is that this circular, it is a statutory circular issued by your department.
Correct.
Can you defy?
No, my lord.
You can't.
No.
Then pay the interest.
No, my lord. Now the question is, my lord.
Pay the interest.
No, my lord. I bow down, my
Pay
lord.
the
Now the question is, my lord, interest. Not question is not the
further cost.
No, no, my lord. It is the question. It is now is the question of interest. It is not a question that whether the order has been passed within the stipulated period 6 months or not. So now, my lord, kindly, my lord, two situations arise.
Make an assessment and make him to make and force him to make the payments. Immediately thereafter, he gave all the documents that what assessment which you have made is not correct. You have charged excess, it should be less. What you are expected to do, you should decide it within 6 months. You did not. 14 years you slept. I am not saying in a slumber. Must be in a very comfortable couch.
That will not.
You must be there.
That is there, my lord. That is on the
So,
record. I cannot develop more than that.
If you cannot, then in that event, this judgment is staring at your
This judgment, kindly bear with me, not one. This judgment is treating that the so-called notice has been
Show us the another judgment contrary thereto of another High Court or a Supreme Court. Show us.
My humble summary here is not now the question is not before the tribunal whether this order has been passed 6 months or not. The question before the tribunal is the date of payment of interest. And my lord, if the date of interest will arise, my lord, then we have to refer my lord 27A. We cannot go beyond that, my lord. And the tribunal, my lord, how can my lord compensatory interest can be directed?
He had to approach many times to you
Correct.
for disposal of even
Absolutely correct, my lord. I bow down, my lord. I am with the petitioner, my lord. I am not on that. But the fact remains, my lord, the revenue has to go by the my lord, 27A for payment of interest. And the tribunal also teaches tribunal can, my lord, I bow down, my lord, tribunal can, my lord, direct to pay interest on date of payment of the duties, my lord. That is what, my lord, situation here. I am not saying that we are not able to, absolutely, my lord, I am sorry that we are not able to complete the assessment within the stipulated trust given by the board circular, my lord. I bow down. So part of interest, not 12%. In the highest part, and even then, my lord, we have this circular of 6%. There is no such reason, my lord.
So that is what we say that instead of 12.6, we indicated, I think, at least half an hour before when you handed over.
So therefore, my lord, I humble submit your lordship formulate a question of law, then your lordship pass a judgment.
What question? I will say that it's not a substantial question of law. There is a distinction between a question of law and a substantial question of law.
Absolutely correct.
And the statute requires a substantial question of law.
Absolutely.
So we don't find it's a substantial question.
I leave it to lordship, my lord. But the fact remains, my lord, my submission we recorded in that part.
No. And after recording the submission, then something at the last should also be recorded.
Maybe.
And my lord,
Yes.
But that is what, my lord, I understand, my lord, the tribunal, whether, my lord, I still mind hampering, my lord, whether tribunal has power to direct beyond the statute. My lord. That is what, my lord, is troubling to me, my lord. If your lordship, my lord, think that is correct, my lord, then, my lord, I have nothing to say. Therefore, my lord, I humble submit. My lordship, formulate a question, my lord, I come up with the other judgment if I find out.
Then what is the remedy according to you of a person? If person has approached the authority saying that you have not paid interest, you are liable to pay interest.
He has come up directly to
authority,
the order.
Please, the authority says that, sorry, I do not think that any interest is to be paid. Then what is the remedy of the person? Where he will go?
My lord, he has to come up to your lords, this court, my lord, challenging that order.
So we are assuming that jurisdiction and
Yes, my lord,
the order of the
I'm Lord Humble Summit is
treating the said act.
There is a
there is no difficulty.
Yes, that is up to your lordship. But that is my
What is this?
That is, my lord, that is my humble submission, and that is what I understand, my lord. So for my little knowledge, my lord, that is what I something.
my lord, insofar as the power of tribunal is concerned, my lords, may I submit?
Yes.
My lords, insofar as the power of tribunal is concerned, they very well have the inherent powers to grant the interest on the basis of equity and justice, and this has been held by various high courts.
Yes.
My lords, the decision of Honorable Calcutta High Court in the case of B. Arun Kumar and as well as the decision of Division Bench of Honorable Calcutta High Court in Saurav Ganguly, both these decisions, they say that the tribunal has the inherent power to grant the interest. Even if there is no specific provision under the Act, still the tribunal very well is within its powers to grant interest on the basis of equity and justice. And my lords, insofar as the rate of interest is also concerned, they have given clear findings. The tribunal has given clear findings why 12% has been adopted.
Then the question, then it is a good case for admission. Then the question arises that power to grant an interest is one thing. But if only for the purpose of the interest, whether the tribunal can assume. Suppose an assessment has been done and the tribunal is competent against the order to go into that aspect and then found that this assessment order is bad, and then he can quash the order, he can impose a interest also as a compensatory measure. But suppose whether the tribunal, first thing is whether the tribunal was competent to entertain any application in relation to a nature of the order which was passed by the.
My lords, I'll clarify the fact on this. My lords, I got the refund. My lords, may I submit? My lords, may I submit?
Yes.
My lords, I got the refund in April 2022 of the excess duty. After that, I filed a letter. I filed a letter before the adjudicating authority.
I could not convey my intention very clearly. Show us the provision of the tribunal where the one can approach the tribunal against.
My lords, I have not directly approached that. I have filed an appeal against the order of Commissioner Appeals.
Show us, there must be a provision in the Act.
Section 129B.
Of this section.
Section 129B of the Customs Act.
129.
B of the Customs Act.
One 129A, not B.
B, my lords, B. Orders of tribunal.
Sorry, A.
My lords, 129 is the appeal that I can file, and then 129B is the powers of the tribunal to pass orders.
I asked you where is the right of an appeal to the tribunal?
129A. 129A.
The tribunal can. There is no difficulty. It was against an order of the
Commissioner.
Appeal.
Commissioner.
Sorry, then it can. Sorry. the short point involved, should I? The short point involved in the instant appeal. Sorry. It is a substantial question of law which is to be there. The department have filed the instant appeal, excelling an order of the appellate tribunal under the Customs Act on the ground that the tribunal is denuted of power to grant compensatory interests over and above the amount of refund which was paid in excess by the SSC. Substantial. Oh, no. If the High Court is satisfied, value of the goods for the purpose of necessity. My brother is going against you more, quoting the provision which says that only in 2 instances the High Court can be approached.
130. 130.
Look at it, more dangerous.
Substantial question of law.
No.
It says only in relation to a dispute as to the rate of the duty of the customs,
Yes.
or to the value of the goods for the purpose of assessment. That's the only 2 questions. And then if it involves a substantial question of law on these 2 counts, then only. Anyhow, we are not going to that aspect. Yes,
What has order under section 129 be an order passed by the thereafter, my lord, 110, any order passed 129 capital B.
Where? 130.
Yes, my lord.
Appeal to High Court.
Yes, appeal to High Court.
You are in 130.
Yes, 130.
Yes.
High Court tribunal then being relating to anything determine the question of having shown so commission, custom, other party agreed by any order passed by the appellate tribunal may file appeal. My lord, subsection 2.
Which one? Anyhow, we are not entering into that aspect.
Any order passed.
So that any order relates to subsection 1, sir. Can you expand the horizon this way?
But that then,
Mr. Satpathy,
yes,
subsection 1
Yes.
gives you the scope to come to High Court
yes,
under a limited circumstance.
yes.
So that circumstance cannot be expanded under subsection 2. Your interpretation will be any order relating to those 2. Then why that subsection 1? It would have said in subsection 1 itself that any order, any decision, like 107 OGST or CGST.
102.
How can you widen it? So such an interpretation will lead to absurdity. Subsection 2 will yield to subsection 1.
My lord, do you have to read it in full?
You
My
have
lord,
to read in that conjunction.
you have to read in full, not the part of it.
Huh.
So therefore, if you read 1, 2 will be coming to the rescue. My lord.
So you are excluding.
No, I'm not. I'm totaling totaling 130.
If you read subsection 1 along with subsection 2,
What has
then subsection 2 will yield to subsection 1 conditions.
Yes,
amount
that part has not yet come up with any
refund? Amount
Anyway,
refund
Subsection 1
in
नहीं.
excess. What have said? No. Read. Which point? It's stated. No. Which was paid in excess by the SSC. And the ink, quote I am giving it. The department has come up in appeal against the order of the tribunal constituted under the Customs Act 1962. Whereby and whereunder the direction is passed upon the department to pay the interest on the excess amount of custom duty retained by the department for a considerable period of time, and even the adjudication to an application claiming refund was done after an inordinate delay, unexplained inordinate delay. The undisputed facts emerged from the record is that at the time of an import of a goods, the duty was cast upon the custom authorities under section 18 of the Act to direct the parties to pay any duty leviable on the said goods, pending the productions of the documents, proper documents, or furnishing of such informations, or a completion of such test or inquiry as a provisional measure, and upon furnishing of all such documents, it may assess the duty finally. Stop. Undisputedly, on the basis of a provisional assessment of the duty, the respondent made the payments and the goods were clear. But after collation and or collection of the various materials, the dispute was raised that the amount of duty leviable on a category of the goods so imported is erroneous, and it should be classified under a particular category which attracts less amount of a duty. Undeniably, the authority accepted the aforesaid contention and decided to accepted the contention that the excess amount of a duty is paid by the respondent, and his right to get a refund gets crystallized. Subsequently, an application was made. Now, so despite the same, there appears to be an unexplained inordinate delay of nearly 14 years in arriving at such conclusions and accepting the contention of the respondent. And it is also not in dispute that the excess amount was refunded from the date of the order. Subsequently, the representation was made for payment of the interest as the excess amount was unreasonably withheld, and the adjudication spanned over more than a decade and a half. A decade and a half, And, and therefore, the interest on the on such excess amount is required to be paid. The authority assess. Now, authority took a decision thereupon, and ultimately the matter reached to the appellate authority, and ultimately to a tribunal, granting the interest at the rate of 12% from the date of the first assessment order. Stop. Mr. Satpathy, the learned were
Senior standing counsel.
senior standing counsel appearing for the appellant submits that the tribunal is denuded of power to grant compensatory interest and therefore the order suffers from illegality and or infirmity. Stop. He further submits that the tribunal cannot exceed its powers in the jurisdiction vested under section 129B of the State Act. More particularly, when sections 27 capital A of the State Act postulates the payment of interest from the date of an order
Application. Date of application.
from the date of the what?
Date of-
27A.
Yes, date of application for interest.
Yes. From the date of an application for from the date of an application made by any person claiming refund or from a date of an order passed by the statutory appellate authority or the tribunal. Stop. It is submitted that the period for payment of the amount of refund is provided in the said the provision, and it is undeniable that the said amount was paid within the said statutory period. Stop. According to him, once the amount is paid within the statutory period provided therefore, it does not attract the imposition of an interest. And therefore, the instant appeal raises a substantial question of law to be admitted by this court. Without delving to go into the nuances of the provisions contained under section 130 of the said Act, we invited the attention of both the counsels to address us on the above score. And in course of the hearing, our attention is drawn to the notification number 75/2003 customs within bracket NT issued by the Undersecretary to the Government of India, dated 12 September 2000, the notification number such as that dated 12 September, issued by the Undersecretary to the Government of India, Ministry of Finance, Ministry of within bracket Department of Revenue, fixing the interest at the rate of 6% per annum for the purpose of for the purpose of section 27 capital A of the said act. D'accord. The pith and substance of the case leaves no ambiguity that the excess amount of the duty was paid by the respondent, and an adjudication is spanned over more than 1 decade. That is the 14 years. And the said amount was retained with the department. Stop. We have been given to understand that Chapter 7 provisional assessment of CBIC manual of instruction issued by the CBIC in exercise of powers under section 151 capital A of the Customs Act 1962, the instruction / circular was issued in relation to the finalization of the provisional assessment, indicating the time limit within which it should be ensured in the following. Quote from here, page 56. This one. At page 56 of this, they have given a compilation. In an identical situation, the division bench of the Jharkhand High Court in case of Messrs. Bihar Foundry and Casting Limited versus Union of India, within bracket WPT number 5161 of 2022 with WPT number 4340 of 2022 decided on 4/3/2024, was considering the claim of an interest awarded by the tribunal on an identical facts that there has been a considerable delay of a decade, considerable delay in adjudicating and or determining the same. In the said report, there was a delay of 10 years in taking a decision, and the amount was paid by the department, taking advantage of the statutory provisions, particularly the period within which the same has to be paid. The division bench, taking note of the said instructions / circular as quoted herein above, held that the set period given in the said circular should not be construed simpliciter and instructions to be kept in a file. And non-adherence does not invite any consequences. The division bench was of the view that the limitation for finalization should be governed by para 3.1 of the CBIC instructions. And if any departure is seen therefrom, there is no fetter on the part of the tribunal to impose the interest in the following. Quote, paragraph 21.
My lords, they hold that the assessment cannot be finalized after the limitation period.
Whatever. No, paragraph 21. That's all. Look. Admittedly, the order of the appellate authority was assailed before the tribunal. And it admits no ambiguity that the moment the tribunal exercises the jurisdiction, it can take note of the mandates of law and may award the compensatory interest. It is inconceivable that the authority sat over the issue for a considerable period of time, despite para 3.1 of the CBIC, the instructions, and unreasonably taking advantage of the nuances of the law that the provision mandates the payment within three months from the date of the order. Despite such order is passed after 14 years from the date of an approach having made in this regard. The court cannot remain a mute spectator and extend the substantial justice extend the several justice after balancing the technical objections. Stop. The substantial justice is pitted against the technical objections or of such nature, the former must prevail. Stop. We do not find any fetter on the imposition of an interest for a delayed payment. Under section 27, capital A of the say that nor we find any fetter on the part of the tribunal who is now before whom the order of the appellate authority is assailed to pass such order. The hierarchical system of adjudication provided in the statute does not create any brindle into the exercise of the powers so conferred. And the higher forum is not denuded of power to take a decision whether the decision of the should I use the word inferior forum? Nowadays glossary of those words. The decision of a authority below it. I'm avoiding that word inferior jurisdiction or inferior tribunal because of the glossary of words published by the what? Can withstand on the parameter of law. We do not find any obstacle in activating the provisions of the statute conferring power upon the authorities to impose interests. And the moment the authorities have exercised such power, it does not raise any question of law to stop. Even a division bench of the Jharkhand High Court has interpreted that the delayed disposal of the matter, despite the mandate given in the set manual of instruction, having a statutory flavor, cannot be subverted, taking aid of the technical rules, which we find cannot stand in the way of the tribunal in deciding the same. However, we appreciate the contention of the appellant on the notification dated 12 September 2003, where for the purpose of Section 27A of the Customs Act, the central government has fixed the rate of an interest at the rate of 6% per annum. Stop. We therefore find force in the submission of the appellant. In this regard, the order of the tribunal is modified to the extent that in state of an interest at the rate of 12%, the same shall be paid at the rate of 6% from the date as indicated therein. That's all.
My lords, the CSTAT has relied upon the decisions wherein the tribunal itself has granted 12% interest rate in other cases.
Sorry, there's a circular prevail over that. Anyhow.
And my lords, just a small modification. My lords have referred import. This case is of export. So that is the only minor change.
Of export. Okay.
I'm grateful, my lords.
Yes. It's called. Yes, next. What is this? Fresh admission, please.
May I please, the Lord.
Item 9.
After this, just for 1 minute more. Yes, what is this?
Item 9, your lordship. I have entered through the caveat, your lordship, and copy has not
Copy has not been served.
No, your
Serve a
copy in the.
serve a copy. Yes,
Your lordship.
serve a copy and matter to appear.
Your Lordship. Lord, subject to your Lordship's guidance, yesterday I tried to find out the judgments regarding the delay in implementation, not in the like imposition, but implementation of the punishment order. But unfortunately, I couldn't find any where regarding the after imposition, there is a delay in implementation. So everywhere it's the delay in the proceeding and imposition, but not the implementation of the imposition, that, my lord. But
We also could not get hold of that.
yes, but anyway, my lord, just before I go to that, I'll just try to take your lordships to a few documents which we have filed before the Honorable Single Judge in the writ petition. In fact, that will show that there is neither any irregularity on my part, concealment, but it has been their stand or their fault for which I have been made to suffer. If your lordships may see, starting from
Does it require an extraordinary approach?
Well, rather, I would say it's a very ordinary case if your lordships would just go through the date lines and the documents available on record.
It's not an ordinary case, sir. There are two things. The single bench has really put a onus on you.
But
equally,
leaving apart, my lord, whether they can put or not, I am not even on that. Whether I have derelicted my duty so far as implementation is also
there are two
concerned.
facets. One thing is that you were all along aware that there has been a penalty inflicted on you.
And they have been communicated all along also, my lords, by different authorities.
I do not know, but
Lord, that is on record. That is why, my lord, I said if if your lordships can grant me 5 minutes
and
to place those documents which are on record.
We are also thinking about it that once that order is there, why the onus will be on her. It is a employer who has to take a call.
Yes.
If they sat over the right for a pretty long time, in the meantime, 2 promotions have been given. Now that will impact those decisions as well from a retrospective effect.
No, it may not also
Acquisitions theory will not come.
no, otherwise also it may not affect even retrospectively because the effect can only be for 1 year.
Oh, I understand.
My lord, in view of the order passed under Annexure 5, that is enclosed to the writ petition, my lord, the promotions which has already been given to the petitioners will not be affected. What has been affected is his further XC2 promotion to the cadre of IAS, where his name was in the list, but because of infliction of that punishment in 2020, his case for further promotion was not considered.
Suppose if it had been implicated or implemented, then the first promotion he received should have been impeded for that.
No, my lords, it could not have because the life of that punishment was 1 year.
1 year.
Please.
And
what he's saying is the further.
yes.
I'm talking about.
No, the first promotion,
was,
yes.
So twice the promotion
Twice
was
the
given.
promotion.
The first promotion was there. That should have been not given because 1 year. But if that is already given,
That is not going to be affected if
question is not a affectations. The
My
question is after such a long time, why should be what she should be put to such kind of a, the obstacle or the hurdle in her further promotion.
but further promotion, my lord, Annexure 5 was never assembled with a single judge.
Why did they implement that? Had you implemented, she could have undergone.
My lord, she was continuing as an administrative officer, and it was upon
That is what I
him.
say. That is what we think is.
Well,
Yes,
that if one increment you stop,
yes.
then what will happen? She has to refund whatever the amount which she has received.
She has refunded also.
Correct.
No, she has
And
not.
now question is that why there should be some kind of an impediment to be put now for her consideration of her candidature for next promotion.
My lord, the punishment has already been worked out. But your lordship may kindly see Annexure 5 for a moment, my lord.
Date. From which date?
From 2020?
That is
From
when
20,
When the imposition was done?
imposition
2011.
2011?
Correct. So if it is done from 2011
Yes.
and then you are giving from a prospective date, kindly visualize the situation. Then what the I would say prejudice she will suffer.
My lord, if he was prejudiced by the order which was passed in 2020 in punishment.
He was happy if it is implemented in 2011 for 1 year.
Yes.
Then that is over.
Yes.
And then the moment it is over, then she should have been considered for the purpose of promotion, even for a future promotion now.
But that order was never challenged.
That is what please consider.
Yes.
What troubles us is something a very unique facts. Imposition was done, penalty was imposed in 2011.
Yes.
Had it been implemented because she accepted that particular penalty.
And as per rule,
Would have
within that
ended in
year.
2012.
Yes.
At best 2030. Then she could have I would say, a free march
Yes.
for her promotion.
Yes.
Even for a future promotion one which she is now undertaking. But if you implement it from a prospective date of 2020, then the embargo has come, the prejudice will come. What will happen? Why?
But my lord, if an order is passed, a punishment is imposed, and that remained unchallenged, then it has to be given effect.
Given effect from which? That is what is the question. Given effect from a retrospective date or from a prospective date? Please consider. Otherwise, there is no difficulty. You impose not to be considered for a further promotion.
No, my lord.
Had those been implemented within the time,
My lord, that order was communicated by her successor, who was the administrative officer.
she
communicated.
she left. She was transferred within 3 months from the date of the imposition.
Yes.
We have read it. So she was not holding those, and it is not a case of anybody that this order of punishment was not there in the file or taken away from the file, taken away or somewhere it was hidden. It's not her case. And nobody's case, even your case is not there.
But our case is
Inadvertent.
she was in the health affairs.
That I have read it
Yes.
because this
I have
was something which troubles me as well. So I was reading and then trying to find out from the pleadings that anything which I can. But I just tried that whether because there cannot be any period of limitation provided for implementation like a civil decree. There is a limitation act. It does not apply.
My lord, in absence of any perversity in the order of the Honorable Single
It's not a
Judge.
perversity. Please,
My lord,
please.
merely
you are
because
not
another view is possible.
No, you are misdirected. It is not a case of a perversity in the decision.
Yes.
It's not a case of a perversity. It's a case of sitting over the right for a particular long period of time and then exercising such right. Now, we are thinking in a very larger perspective. If there is a malice in the mind of an authority and found that this candidate against whom this imposition has been done is a most deserving candidate in future and will attain a particular position, the authorities sat over the matter when a right accrued, implemented it to destroy or diminish that right. It's not a case of malice. With a malafide intention, you wanted to implement so that that right is curtailed or taken away.
But here the malice cannot be attributed to the authority because
said inadvertently. I have seen.
Yes.
You have been playing very safe.
Because twice permission was given to Miller.
In ignorance of that.
Yes.
The moment now, malice when it comes. When you realize that now she has been given a promotion, everything is there. She is the most deserving candidate for being considered for a next promotion, which is the highest post of the service. And then some, if I...
But my lord, the records are otherwise, my lord. Because as soon as it was intimated by her successor, who was
And their own circular, my lord, which is at page 41 of the brief of the WPC, annexure 9. If your lordship should see, they say that it has to be within the placed in the year in which it is awarded, the punishment is awarded.
Page
That is
180, page 186.
No, that is, my lord, I think the briefing.
Computer page
Yes,
92.
yes. Let's see. Let's see. Let us ponder upon the issues. What can be? What weapon you have in your armory?
Yes, my lords. Your lordship may first come
No. Any judgment?
The judgment, my lord, is as my lord presented before lordships. There is no direct judgment regarding implementation, but delay in the inquiry process. So, because there is absolutely nothing, my lord, which I could regarding the implementation. But if we, my lord, take the corollary that the disciplinary proceeding culminates with the award of the implementation of the punishment, then maybe these judgments can be extended to that extent. Because not the imposition of punishment only, but implementation also. Because otherwise, my lord, that period is a very area where nothing is there, my lord. In fact, I could lay my hands on.
I would rely on only because on on this particular fact, we could not find any judgment. But I would rely on this judgment, if your lordship may kindly appreciate. This is of 2025, where they have taken note of the judgment rendered in case of management of Narendra and Company Private Limited versus Workmen of Narendra Company Respondent. It's 2016 3 SCC 340 that has been referred at para 36. AIR 2025 is. AIR 105. Lordship may kindly come to para 36 of this 2025 judgment, where they have taken note of this 2016. I'll just place that para 5 of 2016 judgment that is referred. The relevant portion in bold, my lord. Be that as it may, in an intra-court appeal on finding of fact, unless the appellate bench reaches a conclusion that the finding of the single bench is perverse, it shall not disturb the same.
There is no quarrel to the proposition.
Yes.
That if there are two possible views on the facts, then if one taken by the single bench, that the appellate court should not interfere. Only exception is that the facts which is now taken into consideration appears to be either without being supported by any material before it, nor any evidence to be adduced in this regard. In that event, it is called a perversity. So the perverse judgment can be interfered on facts.
Yes.
We are
But
not
here
on
there
that.
is no
We are
question
not
of
on that.
perversity.
There is nothing. Who disputes?
And even annexure 2, my learned friend is referring to, that he has timely communicated to the authority. That has also been taken note of by the Honorable Single Judge in a particular paragraph and come to a finding that that letter itself given by the petitioner is not reliable.
No, my lord.
Because that was not an official communication to the superintendent.
Yes, that is why, my lord, under RTI, I have obtained the communication.
And there was no acknowledgement.
The acknowledgement on that, if your lordship should see page 54 of the brief. The very same letter under RTI I had called for, because that was denied by them.
54 of the appeal?
No, my lord, the original WPC. That is annexure, my lord, 11. And at page 55. If your lordship should see left side bottom, DDO for needful, signed on 27/12/2011 by superintendent of the SCV Medical College. And she was working at that time in the same hospital. So she would not go and send a letter through registered post or a speed post if they are working in the same office.
And this was received
in 22. I called for it through RTI. My lord, the previous page is my application.
You can't
in 2011 itself.
The communication is received
2011 itself.
So, and these are there on the record.
My lord, may kindly see annexure 2. Annexure 2 is the letter which the petitioner has addressed.
The same letter.
Yes, my lord.
That is what
she herself has written.
My lord, she has
written.
She in the capacity of administrative officer has addressed a letter to the superintendent. Yes. It does not bear a letter number. It's an official communication. Had it been an official, your lordship may kindly.
Left hand side, there is already a name, some kind of an endorsement which is there.
Endorsement is with respect to the enclosures he has given.
No,
there is no
CDO for needful, and who is the signatory?
The superintendent, HCP Medical College Hospital.
So, and relying on that, because she claimed to have received through RTI.
Yes.
So
the previous page is mine.
There to deduct that.
Yes, DDO can only deduct.
Effect to that.
Yes, because DDO has that
punishment
this thing to him.
On the same day.
Yeah. Because she submitted a letter that is annexure 2, and this is the
This
letter
is the
which
same.
was taken into consideration by the authorities later on. So
That-
endorsement she
that
will
is-
not get it.
That
in
is
annexure
also
2.
diarized because of memo number,
Yes,
diarized.
diarized and also
No, that was communicated to additional secretary.
additional secretary.
This is the memo number is also given.
Yes, man.
And 1406 R with reference.
Yes, madam. To that, the order of punishment.
Then entire document was sent
Entire
to
was, and also, my lord,
the
I have
department
brought
concerned.
another
But your
communication.
lordship, I kindly see
Reven-
page 29 of the writ appeal. Page 29. This is the finding of the honorable single judge.
No.
Page,
What
page
about this?
29, para 10.
What about this document?
But
How
this
you have
document has
taken-
been taken note of and the finding.
So
your
in
lordship.
your counter, what have you said about annexure 2? What is your reply to annexure 2 in your counter? What stand you have taken before the allotted single judge?
This, he must have missed that particular letter which he is referring. There has been an endorsement.
Endorsement.
There has been, so is the
Clear.
finding is perverse.
Clear.
Absolutely.
Your-
It's the
your-
op-
your
it's the
lordship,
apparent case of a perversity.
But our stand has been recorded at page 26, your lordship, may kindly see. Page 25.
Which page?
Page 25 of the writ appeal, my lord. That was our stand before the honorable single judge.
From your counter, you just demonstrate.
But that has been taken note of by the honorable
No,
single.
no, please. Please come to your counter. Demonstrate from your counter. Don't go beyond.
Anyhow, let us consider this case and we'll pass the. We have seen that. Yes. For orders in the next week. Dreadful. I'll give you that the hard copy. Along with the writ.
Subject to lordships, okay, require, we can give a short note highlighting these, the factual infirmities in the judgment and the document.
File it then.
By Monday we'll file it. We'll also step past orders any day next.
Written notes of submissions might be
Written note
filed by
already on
respective-
record.
The respective parties by Monday.
By
By
Monday.
Monday.
It will be on Monday.
Let it be listed on.
Let us see.
Grateful.
Directive principle subscript policy. Yes, it accounted for you.
Finish.
Because it's your matter.
Yes, call. No, 2 p.m.
Item 37. sir. Item 37 fixed for 2 p.m. sir. Yes. I thought that my learned senior is standing up.
To conclude his submissions.
No, he has not started. I think his matter has not been called.
Item 37.
No. Which matter is yours, sir?
Serially.
Serial 11. 11 serial.
So everybody wanted his matter to be taken up first.
No, I thought that because a senior person stood up, you'll see first.
Yes, you can, then we can go after 12.
No.
Yes.
11. His matter is 11.
11. Yes, we can go after 11.
11.
When you are there, then.
May I please your lordship? My lord, I filed this appeal against the Honorable Single Judge order. He has passed order.
Which for the railways?
My lord, no railways there in no. Only state is a part. Allowed the writ petition. Yes, allowed the writ petition.
No, you have claimed that they have forcibly demolished the structure
Yes,
and
but
then
they-
utilized the land for the overbridge and a
Yeah.
market complex.
yes. But they have not made any.
Whether it was your property or it was the railways, so anybody is appearing for
No,
the other side.
It is government property. Government has given the railway.
I do not know. I have not seen the cost estimate.
I was
Oh.
for more than 40.
Why you did not make the railways? Because it is the railway who has constructed the overbridge.
Bridge, but government deciding the matter that
Then you have not implemented the railways as a party.
railway directly has not taken. Railway government has given the railway, and market complex has been constructed by the government, not.
So have you served the copy on the railways, on the government?
Government, they have served copy,
Yes.
but in fact, the judgment has been delivered in favor of the petitioner. But he has challenged the appellant in favor of the appellant to the extent
Oh,
for
judgment has
award.
been delivered.
Yes,
Judgment has been delivered, man.
Then
In
in your
his
favor,
favor.
then why you are
My lord, the judgment has been delivered, mentioning therein that the writ petition is allowed.
Yes.
But my prayer has not been considered, and no
That
direction
means
has
all the prayers which you have made in the writ petition is allowed.
allowed. But what can I do with that order, my lord, in spite of any direction?
No, sir. Please consider when you have made a multiple prayer in the writ petition.
Multiple,
And if-
two prayers. There are two.
Correct.
Yes.
Let us see. I withdraw my word. 2 prayers were made,
Yes.
and the single bench says that a writ petition is allowed. Means
Yes.
both the 2 prayers are allowed.
Yes.
So why you are aggrieved, sir?
One direction, if not,
One direction.
I am entitled for compensation, my lord.
So that is allowed. You must have prayed for.
Yes.
So it is allowed.
But when government will take this order, they will not pay me any amount. This is the,
What was the prayer in the writ petition?
yes, I am reading, my lord.
देखो तो
My lord, they are in the circumstances stated above. It is therefore most submitted that your lordship may be gracious in please to quash the order of collector of OP number 3 under annexure 8, having no jurisdiction to entertain the division petition.
So that has been allowed.
Yes, that is a formality because he has no jurisdiction to entertain.
Oh, that is the writ court has also held he has no jurisdiction.
Yes,
And caused and set aside his order.
because he is but and further be pleased to pass order directing the opposite parties 1, 2, 3, and 4 to pay adequate and suitable compensation who have directed for demolition of the houses, well, other structures of the petition for construction of a railway overbridge and a market complex as under annexure 5 of this petition. That is the report of the
So
commission.
this compensation has not been dealt with.
No, without notice, which infringes the fundamental constitution and human rights of the petition, as provided under Article 300A, Article 14, and Article 21 of the Constitution of India, which is proved fact of right, title, and interest. My lord, this is the fact that the Honorable Single Judge has mentioned all the decisions of 300A. Article 300. And he has mentioned in your
But
order.
the Tehsildar has said for demolition.
My lord, your lordship may see the order of a single judge. The court's reasoning and analysis.
What is this section 8A of the Odisha Prevention of Land Encroachment Act 19?
Yes, my lord, he has also.
OPLE proceeding, that is Odisha Prevention of Land Encroachment Act. There is a provision for settlement of the land. In case the person concerned has been staying over the land for more than 30 years.
This
Some
is,
considerable
It
period.
has said
We
that
can make
paragraph
application.
16 of the impugned order,
yes,
that the disputed land had already been utilized for public infrastructure,
Yes.
including the railway overbridge
yes,
and the Rourkela Municipal Corporation Market Complex,
yes, ma'am.
leaving no land available for settlement.
Yes,
This court finds it contradictory that the Tehsildar, having issued the demolition order himself, that means demolition of what?
this structure,
So,
my
that is
structure.
allowed.
My structure.
Your structure.
Yes, I have constructed houses where garden etc. So
Possession was
there,
continuous.
it is already been
Is in
discussed
a-
elaborately. It is only to make an order for
That is what I'm thinking, that paragraph 16 is.
my court's reasoning and analysis. Last, yes, this honorable court, the honorable single judge, has honest counsel for the parties and perused the documents placed before this court. At the outset, it is pertinent to emphasize that the right to property is recognized as a human right. Instead of Haryana versus Mukesh Kumar and others, the Supreme Court observed that human rights have traditionally encompassed individual rights. As such, the right to health, right to livelihood.
For the demolition, if the proceeding, if the single bench has held, is a fit case for 8A of the Odisha Prevention of Land Encroachment Act 1972.
Yes, ma'am.
If it is a fit case, then why the construction which he made over the land was demolished?
Court says the 8A now cannot be invoked because there is already two structures standing over the plot and the demolition was carried out by the Tahsildar. That is what the court has.
Please, paragraph 17 is very clear.
Yes, ma'am.
Despite Tahsildar's attempt to dispute the petitioner's possession, the factual findings from the spot inquiry tell a different story. The findings of the spot inquiry categorically establish that the petitioner continuous possession of the land, thereby making a case referable under.
This is what I want to
8A. But your lordship may kindly see 16.
But anyhow, the 17 came after 16. 17 comes after 16.
But now,
whatever, the 17 has to be respected, that he wanted the case is referable under section 18, means meaning thereby
regarding settlement.
Settlement.
But
now if the structure is demolished, then who will pay the compensation?
But his structure was demolished, and by efflux of time, my lord, the railway overbridge and the Rourkela Municipal
I can
Corporation.
understand, that is why
Yes.
paragraph 16 says that it is for a larger public interest.
Interest it has. So
Now-
only with respect to compensation.
So what?
I'll have to take instruction. This has come for the first
Compensation,
time.
pay him full one,
My lord,
or
this has
if there
come
is
for the
an
first time.
alternative land, but the court has said that no, construction may have come up, but his continuous position is still recognized.
Yes, that has been recognized in the
So-
judgment. Now, whether they have decided to go to challenge this judgment before this forum, I don't know, my lord, because this matter has come for the first time. I'll have, otherwise the authorities, whether they have gone for challenging this order before this honorable court.
What is this annexer 17 in the writ petition? Yes.
Petition is
Oh, that is a direction for disposal of revision case.
revision has been quashed, my lord. Revision order has been quashed. Thereafter, no order has been passed directly.
It was relegated
Correct,
to,
yes.
relegated to, that's.
So that is possible.
Take instruction and then come up.
I'll take instruction.
So 1 week after.
20th.
Yes. Yes.
For instructions. After revision.
1 week after. We are, that should be somewhere in 23rd week June. We are reopening on 17th.
After vacation.
Item 37.
Yes.
এটা দেখা যায় this. There is an there
Yes,
is,
sir.
I thought I should come here because there is an obstruction. I can't see you.
Oh, you can come here.
No, I am here. I am comfortable here.
Ah.
So that, let two things I was submitting to your lordship yesterday. That this right is not absolute, right to trade with liquor, number one. Number two, the restrictions imposed under the rule.
Excise Act and the rules.
The restrictions imposed under the rule are reasonable and conforms to the constitutional norms embodied in Article 19(2) and 6. Lord, if your lordship remembers, the old is always gold. I am citing in this context, my lord, one judgment of a constitution bench way back of 1952. That is Kavarji Barucha. Your lordship knows it's a famous judgment which has been oftly quoted so far. Article, and incidentally, it's a foreign liquor case. There are two aspects which emerged. It's a short judgment, but very apt. But may I place the background of the case in para 2? The collector of excise has been respondent number 3. On 16/5/53 held an auction sale of Chang Gate Country Liquors of Bewar for the year 1953-54, pursuant to the rules framed under the Excise Regulation 1 of 1915. The petitioner and respondent number 5, Chogalal, offered their bids at the auction sale. Chogalal, whose bid was in sum of ₹50 million, this was the background, it was questioned. But the point of law, which evolved, your lordship may kindly turn to para 4. What was the point of law that was founded? That the petitioner's fundamental right to carry on trade or business in liquor under Article 19(1)(g) has been infringed by the act of the collector of excise in condoning the failure of the respondent in depositing the whole of the security deposit required under Schedule 8A of Rule 6 of the auction rules within the prescribed time, and not in re-auctioning the license under the sub-rule 9 of Rule 6, that in allowing Chogalal so-and-so to make the deposit after the expiry of the prescribed time, the collector had discriminated between him and the Chogalal, and thus abridged the petitioner's fundamental right under Article 14. It is alleged that the petitioner had known that the collector would enlarge the time for the security deposit, he would have offered a higher bid. That the Honorable Minister of Excise, so-and-so respondent, had no authority under the regulation to confirm the auction sale held by the collector. That the summary rejection of his appeal without hearing was not justified and has resulted in the abridgment of his right to carry on his trade. that the provisions of excise regulation and the auction rules made thereunder were ultra vires, as the same purport to grant monopoly of the trade to a few persons, and are thus inconsistent with Article 19(1)(g) of the Constitution, and that the provisions of the regulation regarding levy of license fee with the avowed object of raising a big source of revenue also seriously affected the fundamental right of the petitioner under Article 19(1)(g) of the Constitution. On these allegations, the petitioner prayed for a writ of mandamus or a writ in the nature thereof, or a direction or order on respondent 1 to 4, directing them so and so. Let's para 6 is 7 important. Is I may not go to it. Your Lordship may straightway.
Paragraph 7 is very
Paragraph
important.
7 is important. Rightly, my lord. Article 19(1)(g) of the Constitution guarantees that all citizens have the right to practice any profession or to carry on any occupation or trade or business. And subsection 6 of the article authorizes legislation which imposes reasonable restrictions on this right in the interest of the general public. It was not disputed that in order to determine the reasonableness of the restriction, regard must be had to the nature of the business and the conditions prevailing in that trade. It is obvious that these factors must differ from trade to trade, and no hard and fast rules concerning all trades can be laid down. It can also not be denied that the state has the power to prohibit trades which are illegal or immoral or injurious to the health and welfare of the public. Laws prohibiting trades in noxious or dangerous goods or trafficking in women, trafficking in women cannot be held to be illegal as enacting a prohibition and not a mere regulation. The nature of the business is therefore an important element in deciding the reasonableness of the restrictions. The right of every citizen to pursue any lawful trade or business is obviously subject to such reasonable conditions as may be deemed by the governing authority of the country essential to the safety, health, peace, order, and morals of the community. Now, this is where it's a morals of the community. Some occupations by the knights made in their pursuit, some by orders they endanger, and some by the dangers accompanying them, require regulations as to the locality in which they may be conducted. Some by the dangerous character of the articles used, manufactured or sold, require also special qualifications in the parties permitted to use, manufacture or sell them. So those propositions were not disputed, but it was asked that there was something that is not, this is important. So my humble submission before your lordship, it is not a prohibition of sale of liquor. It's a regulatory measure to, my lord, restrict the entry of certain category or to perform certain acts which is not, my lord, decent. I can't say it's decent, which is against morality or which endangers the safety of women. So these regulatory measures, my lord, while granting the liquor is permissible. Under the law, it's within the legislative competency. So the Bombay Act was on a different context. There was a complete ban. Here, my lord, we are permitting orchestra and music. Orchestra also includes dance. If your lordship would go to it, any melody or music system, whenever it is played, nobody is precluded. But that is subject to restriction. So, my lord, that is why when we came across sporadic incidences in the city, which, my lord, affected the law and order situation of the city, we had to prevail and intervene in that juncture. That was therefore, my lord, we did it. Only it was earlier there. Experience showed that there are immoral activities, certain activities which are not permissible in the society, my lord, took place. There were frequent raids, frequent allegations, police reports, everything, my lord, taken together. We decided that this kind of activities should be regulated. So therefore, these two words, dance performance, which was specifically there, we wanted to omit it. So this is the thing. That's a very restricted thing, my lord, which has been deleted from the statute by substituting a new proviso. Everything is there, only dance performance, which is also, my lord, included in an orchestra program. Music also. It's a rather broad. Dance, my lord, music also, or orchestra, my lord, there also they dance. There is no prohibition in an orchestra. No, my lord, they dance. And now, if your lordship put, suppose a melody, what is that called? Melody program. The girls are dancing. That is, let dance means what? Let them dance Odissi. Who precludes?
You can't.
Devdasi, your lordship was giving the example. Devdasi is a form of Odissi.
The Supreme Court.
Dance in which form?
The Supreme Court was really giving an illustration.
No, that's correct.
There are various forms of a dance. Then illustration was Devdasi, illustration was...
that's correct. Dance has to, there are several classic dances. Kathak, Kuchipudi, Odissi, so many things. Your lordship, that is, I am not on that. They are not prepared to do that. They want some form of dance, my lord, which would encourage the consumers of the intoxicating
It is
liquor.
frequently, say in the early 80s or late 70s, this concept of a classic dance and the other form of a dance was really recognized. Actually, dance does not really make any kind of a variance.
Right.
Dance itself is a homogeneous class and it imbibes every type of a dance or every forms of a dance within it. So you can't make a distinction that the classical dance is more
if you are
acceptable,
permitting
the other form of a dance are not acceptable. I think
that is
every
acceptable.
dance, which is a dance, is now
dance,
understand
dance,
in that way.
Dance with decency and dance with this kind of activity are different.
Can you make?
That's correct. That is what exactly form of dance they want. The kind of dance which was going on, that created a trouble for the administration. So therefore, we wanted to put a check on it. And
you could have said that only in a case of a classical dance, then it specify what is a traditional dance of the state. Apart from that, no other form of a dance.
So that we can merely introduce, but we can destroy culture with us.
You have
Odissi is not, dance is not performed in a bar, in a liquor shop. I have to also preserve the culture of my state. I can't endanger.
Then you cannot make a distinction.
For the pleasure of the liquor consumers,
Mr. Advocate General, probably I could not convey the wavelength of my mind. I got really passing through it. When you talk about a distinction in the perspective of a dance, for that we say,
let's say I got your point.
That we cannot make a differentiation that this form of a dance is permissible, this form of a dance is not permissible. Had it been the intention of the legislature, they could have incorporated that. They were conscious that any form of a dance in a particular place
is injustice.
As you say that there has been a report.
Right.
So we do not want to continue it. We wanted to put a complete embargo or complete prohibition that you cannot do it. You cannot do it. So far as the orchestra programs are concerned, so far as the musical programs are concerned, let's just say that somebody comes and sings the song. It's permissible. There is no difficulty. Orchestra is something which, because the Supreme Court in that judgment of the Bombay, that Indian hotels, the Supreme Court was conscious. And were very, very conscious about it.
The Supreme Court
says that whenever any word like a musical program or an orchestra, those have to be considered in a more generic terms, in a general or grammatical meaning which is given to that. It should not be interpreted with the canon of interpretation of a judicial, the expressions. It should not. It should be given a very generic terms. So one has to understand in that. So in that perspective here, what their argument was that it is one of the fundamental rights coming under Article 19(1)(a) and 19(1)(g). If there is any restrictions, that restrictions cannot be said to be intra-virus. This is, I think, their argument was. So here we find that there has been a complete prohibition, restriction with certain conditions. That's the reasonable restrictions that can be done. As the Supreme Court in that case says that there will be a 3 feet height, the railing which has to be constructed across the or in the circumference of a dais. The pupils should not be permitted to reach within 3 feet. Within 3 feet from that particular dais. These are the reasonable restrictions to avoid any kind of a thing.
No, that is there, my lord. I'm not on. Your lordship may kindly look at the language which we have employed. It is not unreasonable.
Complete.
The proviso, my lord, initially it was also there. We, my lord, substituted it with this same provision, save and accept this dance performance. Because that created the trouble. During past 8 years of experience, my lord, we experienced that this kind of obnoxious things are injurious to the, not only to the society, to the safety of the women.
No,
But it created
this judgment also.
Judgment has not so say. It has been, that is for inferium. I am going to that extent.
Very interesting observation.
But this is also very interesting.
Mr. Advocate General, this is a very interesting observation that has come in this constitution-based decision, which you are relying.
That's correct.
There is an interesting thing that these restrictions or the prohibitions have to be understood in the perspective of a particular trade. It cannot have a omnibus operation. It has to be on the basis of a trade. And it varies from trade to trade.
Absolutely, Vinod.
That is a very interesting. So one cannot say that there has been such a restrictions in this trade. How can there be a restrictions in this trade as well? That cannot, because it all depends how.
Right.
You are correct to that extent when there is a empirical data which the government has collected.
Right.
There has been a reporting, there has been a study, if it is conducted by the government, which says that these are not conducive, these are not good for the human being or a citizenry of the state. One can think about it. There is no difficulty. But must to be judged on the parameter of the fundamental right.
No, it's not, again, we are coming to this square back. It's not fundamental. Right to have liquor trade is not a fundamental. It has been held here also, Miller.
No. Probably you could not get it. Right to sell a liquor is not a fundamental right.
Not a fundamental right.
But a right to perform a dance, which is now Supreme Court has said is a fundamental right under
the right to perform dance, Miller, outside the bar and inside the bar are two different connotations.
Freedom of.
Just having for livelihood. We can't stop on
that is what 19(1)(a) and G was really introduced. Article 21, right to life was also.
No, that's it. May I answer, Millard. We are, Millard, banning dance. Dance in any form, dance in not in any form. Dance in the bar is, Millard, regulated. We are not banning dance.
I understand.
Dance in a on-serve.
Correct.
In a on-serve. On-serve is different, Millard. From restaurant is also there. Bar is also there. There are, Millard, 100 some odd on-serves in Bhubaneswar and Cuttack. Only 17 on-serves are having this kind of activity. Only 17, not all. So, Millard, in many of them, we have given a data also. I am grateful to your lordship that what is the empirical data. Several raids, allegations have come from different quarters, from the neighborhood, from the neighbors, and up to a night 1 a.m., 2 a.m., they go on raids by the police, by the excise department. It created, Millard, problem for the administration. We were constrained to impose this restriction. That is not, it has a rationale. It has a nexus behind the object. It is not, Millard.
In Indian hotels, the Supreme Court was very categorical. it says that in absence of any such empirical
Your
data,
lordship is correct.
in absence of any
Data, because no
study
data.
being done,
Yes, your lordship is correct.
you cannot put a restriction.
That's correct,
So
that's
if there is a restriction or some empirical data, some study that has come up,
Right.
some reportings that have come up, that is a different aspect.
I'll say that. So, my lord, your lordship may kindly turn to the counter for the time being. I'll come and develop that point. Your lordship, I'm grateful. One additional affidavit, when this question, my lord. Which one? Hotel Ekamra. My lord, one read petition, your lordship may take off Hotel Ekamra.
Okay. Okay. Counter.
This is
You
an
ordered a
additional
counter, yes.
affidavit, my lord. Counter is there. We filed an additional affidavit also.
Additional counter affidavit.
Yes, my lord.
Yes.
My lord, your lordship may kindly turn to Lord, page 4, may I please, my lord?
This is
Para, my lord, the second para.
since the year 2019.
2019 till date of the amendment rule 44, this sub rule 4 and 5 of excise rules 2017. Around 17 restaurant on shops in Bhubaneswar were given permission from time to time by the Excise Commissioner Odisha to perform dance, thereby submitting undertakings that they will adhere to all the conditions of license. However, all of them flouted the conditions over the time and again, for which as of now, number of serious irregularity reports have been initiated and drawn by the excise authorities, and the said offences have been compounded in lieu of cancellation of licenses. That is a compounding, my lord. These licenses were liable to be cancelled as per the terms and conditions. My lord, we didn't do that to protect their business license. Many such bars have been shut down due to creation of law and order situations, including the bar of present petitioner. Hence, these bars have become unsafe for women dancers. My lord, in this situation background, my lord, data is there. I'm coming to that. Therefore, the state government brought the Odisha Excise Amendment Rules 2024 in Rule 44, Sub Rule 4 and Sub Rule 5 by omitting dance program. These two words have been omitted. Everything remains. From its proviso in accordance with law, considering the socio-economic, cultural and safety scenario of the state of Odisha, which is quite different from other states of the country, for betterment of the society and for greater interest of public at large and women's safety more so. Copy of list of SIRs, that is serious irregularity reports, and fine imposed on dance bars of Bhubaneswar is annexed herewith and marked as annexure A by 1. Copy of the list of dance bars. Your lordship may kindly turn to annexure A by 1. The serious series belong. All those data is there, A by 1 and B by 1. Lord, may I place this? I'll come to that. Your lordship may go through it. Every Lord, all these 17. Serious breach. Abuse of the woman. Many reports, my lord, even under PETA Act, cases have been registered. We can tolerate this kind of, my lord, activity to be carried on. It's for the public good. To protect the trade right, let us assume that even though it's not a fundamental, but it's a statutory right, let us assume, because it is conditioned by certain restrictions, reasonable and statutory prescriptions and limitations. They have to adhere to it. They can't carry on a trade, Milan, against the public morality, decency, the obligations imposed under the conditions of a trade license. If they violate, then the consequences has to be followed. We consciously, my lord, omitted this because these two words, my lord, created many problems for the city itself, for the law enforcing authority, for the excise department. Obnoxious. So therefore, your lordship may kindly read further. In reply to paragraph 3 of the writ application, it is submitted. Petitioner further challenges amendment. With the sub-rule, we are not concerned. Your lordship rightly observed that no argument has been advanced, even though the plea has been raised. So therefore, I am not answering that. Sub-rule 5 in toto, my lord, the entire provision has not been substituted. 3 provisions have been inserted which is new. So that has been, my lord, old rule 5 has been substituted by a new sub-rule. In essence, it is the same, save and except the CCTV portion. My lord, it doesn't take away the right of a person. It is for the safety. Anything untoward which happens inside a closed premises, so therefore that is subject to scrutiny in a proper proceeding. It is nothing private. Let's say read para 5, may I place it, Mila?
Yes, sir.
It's not a closed door affair. It's an open place. You can't restrict it to a few persons, and so therefore anything which is a public activity that is subject to be kept on record. That is why, my lord, for the purpose of instances of any kind of malfeasance or impropriety or breach of any of the conditions, etc., that is subject to investigation, either by the licensing authority or by the law enforcing authority. Either way, they are subject to scrutiny. They can get rid of, we have a license, so it is unbridled or uncanalized. We can do with the license in any way we choose. It's not, it can't happen like that. So therefore, my lord, this data we have given A by 1 and B by 1. Serious breach, irregularity. My lord, your lordship may kindly turn to all those instances are there. They have been fined 50,000, 1 lakh. License is liable to be cancelled. Forget about carrying on this kind of activity. License, my lord, that can be cancelled. So this is a ground also for breach of any of the conditions. So, my lord, may I place all those?
I have already read by this.
I know your lordship is very fast, so therefore. So
but if you look at it, the majority of the cancellation is founded upon that they were running beyond the schedule time.
1, 2 a.m.
There are 3-4 instances,
yes,
which you have given that why we have done it.
Right.
The first instances was that they found that the girls are dancing on the common floors.
Right.
So that is, I think that was against some regulations. In some, you find that somebody was showing the color of the money,
right,
and which is also prohibited under that particular act.
Right.
And these were the only allegations.
Right.
And nothing more than that. Everything was that they were operating beyond the scheduled time.
Right. No, other instances are there, my lord. You are
two instances. Yes. One was that they were dancing on a common floor,
right,
which is not permissible. They have to dance at a particular designated place. Second, the customers were showing or waving the money during the musical their dance performance. So that is also offending that particular the rules.
Right.
So on that ground, you have already they cancelled their license or suspended for that. There are few instances which are given.
We had one serial number, page 16, your lordship, Ekamra Hotel. This particular petitioner, serial number 11.
I have not noticed this petitioner.
No, one of the petitioners, Miller.
Yes.
He's one of the, before your lordship.
No.
Therefore, I have to point out.
I read it as a cursory glance to all.
16, Miller, no CCTV. Your lordship.
That's true. That's why I'm saying.
On inspection, it is found that 8 number of women are engaged in the bar. Manager and employees created hindrance and obstacle to government officials.
This is one of the cases.
Not install CC at appropriate mechanism. Lord, is such a petitioner entitled to the equitable relief before this court with this kind of activity? Takes a license from the authority, doesn't allow the
Mr. Advocate,
authorities to get inside.
We are definitely not going into the merit of the case. The
Right.
merit may not entitle him to have that order of cancellation or order of suspension or order of termination of the
Right.
license. That's the one aspect. We are now more concerned with the virus of the
No,
problem.
virus, the person who comes before your lordship challenging the virus should come with clean hand. Anybody whosoever comes and challenge me, Lord, he has to show that a vested right has been infringed. A vested and accrued right under law has been infringed. A violator cannot come and complain before your lordship that my right is to be protected. A person who approaches the equitable jurisdiction of your lordship under 226 has to come with a clean hand, have to satisfy that I have a case, I have not only a case, but a vested right, a accrued right, a right under the statute has been infringed, curtailed or abridged. A violator in essence, my lord, is not a person to claim such a relief in equitable. It's not a PIL. It's a substantive writ petition. He is seeking the enforcement of a right. Therefore, a mandamus. It can't be otherwise. So therefore, on the face of it, a person who violates the law, he comes, my lord, for enforcement of his right. Bombay case, if your lordship remembers, there was a complete ban on dance. That's a special statute. But here, my lord, we are regulating operation of a license in a restricted or exclusive premise. That's if we mark the distinction. So therefore, this constitution bench judgment, my lord, of 1952, though has been referred to, has neither been distinguished nor, my lord, discussed, only a reference. So this judgment has to be taken as per inquirium. You can't override a larger bench judgment in a two-judge bench. So, my lord, even if it's a lateral view, in my humble and respectful submission, a five-judge bench is binding on all subsequent proceedings. Either it has not been noticed, my lord, that's a separate thing. But if it has been noticed, but still then not taken care of, to have some regulatory or restrictive measures while regulating an exclusive privilege premise. So, my lord, that would be too far. The consequences would be too far. Even we can create a monopoly in coded distillery. That's also again a five-judge bench. Your lordship may refer to that judgment I'm just placing. That's a five-judge bench.
No, coded distillery, I know.
Lordship knows it's a famous case on that.
Yeah.
So, my lord, only two paragraphs. If your lordship, yes, two paragraphs. Para 60, my lord. They have summed off the entire, I think in para 60 from A2, it's, my lord, if your lordship put, I may not read, but only E, F and G. The next page at your lordship would find at page 609. For the same reason, the state can create a monopoly either in itself or in the agency created by it for manufacture, possession, sale and distribution of the liquor as a beverage, and also sell the licenses to the citizens for the said purpose by charging fees. This can be done under Article 19(6) of the Constitution or even otherwise. For this, sorry.
No.
Sure.
Yes.
For the same reason again, the state can impose limitations and restrictions. This is important.
Yes.
Let F, small f. For the same reason again, the state can impose limitations and restrictions on the trade or business in potable liquor as a beverage, which restrictions are in nature different from those imposed on the trade or business in legitimate activities and goods and articles which are res commercium. This is this theory, your lordship, I need not again elaborate it.
No, it is borrowed in that from res
yes.
commercium.
Yes.
And they use the word extra res commercium.
Right. So therefore, the restrictions and limitations on the trade or business in potable liquor can again be both under Article 19(6) or otherwise. So, my lord, entry 8 and 51 of list 2 authorizes me to make law. Law authorizes the delegatee to make rule. Rules are, my lord, are subservient to the statute. And 19(6) is to be read with, has to immediately swing in to restrict the carrying on the business in a premises which are under the grant of a license under the Act. It's not unrestricted or uncanalized or unregulated. That is subject to, my lord, reasonable restrictions and regulations. So there, my lord, the right, my lord, is no way infringed. Dance performance banning is not something. Dancing in any form may not be objectionable. But dancing in some other obnoxious form, my lord, which creates a danger to the society, is to be, my lord, regulated and restricted, and that is there. That exactly what the rule says. It is not otherwise. So therefore, your lordship may read further. The restrictions and limitation can extend to the state carrying on the trade or business itself to the exclusion and elimination of others, and or to preserving to itself the right to sell licenses to do trade or business in the same to others. When the state permits trade in potable liquor with or without limitation, the citizen has the right to carry on trade or business subject to the limitations, if any, and the state cannot make discrimination between the citizens who are qualified to carry on the trade business. So that we have not done. It's equally applicable to all unsubs. Not that, not a class of liquor traders are permitted, the others are excluded. There is no discrimination here. In all, my lord, this particular dance performance, we intend to put as a restriction, as a regulatory measure for civil good, for public good, for safety of whom and what so. And the data is there, not that, my lord, your lordship gave the instance, one instance is good enough. Not that a violator, my lord, should be a perpetrator or a habitual violator. A violation, a crime in any form, even in a single instance is a crime. A singular act itself constitutes it may be considered as a danger to the society. So, my lord, in all, I have a plethora of judgments with me. I can cite on 1962, etc., liquor business, so many. I'll give a compilation, it would be better for you. I need not consume public time and waste your lordship's precious time to summarize, my lord. This sub-rule 5 is a substitution, and the moment it is substituted, it merges with the principal rule statute. That becomes, my lord, section 6A of the General Causes Act. I may not go to that. Show this substantive provision when it merges with the principal act, that is the law. So it makes no difference. Earlier provision was this, we have inserted 2-3 extra provisions which I read out yesterday before your lordship with regard to the installation of CCTV and other measures to protect. Not only it doesn't infringe the privacy, because if it is after all a public place, it doesn't infringe upon the privacy of a person. Not that it is somebody is doing it at home, you can do it. Can have that fancy or merry at your home in a closed door. Nobody would go to your home to make a search. Subject, of course, that it is obnoxious. The state has also a right to go. If an immoral activity goes on in my house, the state enforcing authority has a right to go and make a search in my house even though it's a private premise. So it is a exclusive premise which is granted to a particular trader to carry on a particular business subject to the statutory impositions, restrictions imposed under the conditions of the license. If you violate, then the consequences will follow. You can't make the law unworkable or do something which is against the conscience of the society. So that is exactly what the state has done. So in it doesn't violate Article 19(1)(g) nor Article 21 of a businessman or legal trader. The second petition for dance girls, they are before your lordship. One of the, but so far these 3 petitions are concerned, they are licenses. It doesn't in any way violate their right neither under 19(1)(g) nor under 21. These 3 petitions are outrightly are to be dismissed at the threshold. Neither of the conditions or the parameters of the constitutionality are attracted. So far, the invocation of your lordship's writ jurisdiction is concerned. Plain and simple, invites an order of dismissal. So far, the other petition is concerned, writ petition. My humble submission would be not a single the pleadings in the writ petition your lordship may kindly refer. In part way, they are entitled to relief. What is the description in para 1? Copy and paste of all the petitions together, save and except one paragraph about the activity carried on by those petitioners. Your lordship have to grant on the basis of the pleadings. All petitions are copy paste, all 4. The traders and the dance girls. Petitioners are the artists in dance performance, para 1, and perform dance in various social, cultural, and permitted IMFL liquor bars. Permitted. Permitted whom? Permitted by the state. Permitted bars as professional dancers and residing in the city of Bhubaneswar, district Khordha, in the state of A, being citizens of India, come within the jurisdiction of this honorable court. All other things copy paste. This is all the 4 petitioners, except this pleading in para 1. The rest paragraphs are identically worded. Computer must have printed out with adequate. I need not. The same counter affidavit I have adopted.
Plagiarism. So you talk about the plagiarism.
Plagiarism. Recently, one Singapore Supreme Court has.
But need not have to spell. We are conscious of 222 pages. We are. Yes.
Similar, the description in the cause title, who are they? Rekha Sri Khatua is claims to come from Kendrapada. No identity, nothing. Who are they also, nothing is known. No Aadhaar card, I think, is annexed here. We are what we are doing. We wanted the proof, identity proof. Who are you, where from are you come? The number 2 is from West Bengal, Garden Reach. Number 3 from Chandigarh. Miss Jyoti, Miss Madhubhasa, Mubasara, Parveen. So, we don't know how do they come to the city, what kind of activity they are carrying on. How can we permit? How can we? We don't know who are they. But fake Aadhaar cards are being created by a group of brokers in Bhubaneswar. Those things are on record. I do not want to argue on that. I am conscious of the pleadings. That is not there. So therefore, now the larger question your lordship have to address, whether in the context of the city, Bhubaneswar, they call it Mandir Malin. So lots of these it's a temple city basically. They call it Bhubaneswar. That's a cultural city basically, Cuttack and Bhubaneswar both. So we have to restrict, regulate, impose certain conditions which doesn't vitiate the societal culture, the heritage. You drink, nobody says no to drink. You enjoy. Enjoy within the parameters of the permissible sanctions of the society, not beyond it. There has to be a rationale behind every action, and the state is ultimately the regulator. We have to ensure the safety of thousands. For the right of 4, my lord, I don't say that even the right of 1 is to be infringed. Any my lord, proponent of a public right would never say that let the right of 1 suffer. I am not also on that. But particularly when it comes to public order, the public, my lord, order, that is to be, my lord, has to be regulated by certain reasonable conditions. Let these 2 words, I leave it to your lordship to interpret the way in the context of the state's larger interest and all. So, data, my lord, your lordship is absolutely right. It should be substantiated with certain cogent and convincing reasons and the backdrop and the background on which we proposed, my lord, intended to bring out this amendment. So, not that, my lord, we permitted and tested. It all failed. We permitted and tested. Do it, but do it with the permissible limits. If they transgress, then, my lord, the consequences have to be followed. It's the duty of the lawmaker to see that the societal good is to prevail. Lord, I'm deeply obliged for giving me so much of time to put forth my case. And anything, my lord, if your lordship would require, I may prepare a short note with the compilation of all these judgments.
You have already said that you will make a compilation. You just.
I'm deeply obliged.
Thank you, Mr. Advocate General. Yes, anything you want to respond in reply?
Yes, I'll take little time. I'll take little time. It's necessary. The core question, my lord will kindly appreciate, the core question is whether you can put a complete ban on dance performance by deleting the word dance from proviso to rule, sub-rule 4, and whether the state has the power to insert unimplementable conditions like sub-rule 5, my lord, kindly appreciate, sub-rule 5, which have been rejected, being declared either void or modified by Honorable Supreme Court in the India Hotel Association. Okay, that, my lords, no, I have submitted it yesterday. Therefore, now my lords can see who could come before my lords. I'm sorry, I'm sorry, with great respect to my learned friend, my learned Advocate General. The extraneous submissions I don't want to reply. Who could come to my lords under Article 226, whether he is penalized, whether he is having data against him. But data against him about a particular petitioner who is being now submitted was rejected by collector. He said nothing doing. This is your allegation. Your allegations could be at best compounded, and they have issued the license again for the current year, my lord, on 1/4/2025. Therefore, my lords will kindly appreciate how can these kind of allegations, I'm sorry, extremely sorry, that a petitioner has no right to come before my lords in a 226 application because he has been penalized or he has been, his allegations have been compounded. That kindly appreciate. That apart, now my lords will kindly find dance performance is declared as fundamental right. I have already submitted before my lords. My lords will kindly go through that. And Indian Hotel Association case is a directly applicable case to this case. Here, their lordships have dealt with a case which is now the impugned order cannot sustain being in direct conflict with that decision. That is a settled principle. Law is a law of the land. Can my lords, that there is perversity of law? How can my lords be prompted to make a law or go into the matter overriding the settled principle of law, that is law of the land? That dance you may tomorrow, my lords, kindly appreciate, tomorrow you put a complete prohibition like we have. Today
you declare that no bar license will be given, matter ends there. After having that is called permitted. Their lordships have repeatedly used the word permitted IMFL liquor bars, whether in a restaurant or in a hotel. In restaurants, it is permitted, you have given license, so dance performance is permitted there. In hotel, it's permitted. And as regards, well, I will sum up with this because I will not harp upon that Indian Hotel Association case. My lords have completely understood that and have gone through that. As regards the conditions, unimplemented conditions, kindly appreciate for a moment. These unimplemented conditions are akin to those conditions which have been discarded by Honorable Supreme Court. That is on one instance I am submitting, on one instance, that is on CCTV camera. Kindly have a look, my lords, at my brief for a moment. Repeat some for a moment. Page 3. Page 3, kindly have a look.
The Supreme Court has also taken into account the CCTV camera and all
that. That will have chilling effect.
Huh?
Well, what is chilling effect? My lords, kindly have. What is chilling effect? My lord, a member from my somebody's family is sitting in the bar. He will come under the CCTV camera. His family members will know. His relations will know. His wife will know. This is one thing. Somebody has gone to watch the dance performance. That will come on CCTV camera. That is the chilling effect.
And it has both the brighter and the darker side. When you treat this in this fashion, that means then there is something. Then it's not conducive, not congenial. Then it should not be permitted at all.
But
if it becomes a denigration to a person to go there and watch the dance performance,
well, that is chilling effect.
No, then Mr. Senior Counsel, there appears to be a reasonableness.
Chilling effect.
Chilling effect is different, but not this chilling effect.
So, my lord, kindly have a look on that CCTV camera. I am pointing out. On that CCTV camera, I am pointing.
I have not been answered. If he argues this again in the reply, then I have just requested him. I have just requested him that you are in reply.
Simply on, I'm sorry, my lord. Simply on certain unreasonable conditions, unimplemented conditions, I had pointed out to you yesterday that I am simply.
Your case is very clear. Your case is very clear, sir. Your case is very clear. You have said that the dance program or a right to perform dance is a fundamental right.
Yes.
Under Article 19(1)(a) and 19(1)(g).
Right.
There can be a reasonable restrictions, but the reasonability has to be tested on the basis of some empirical data, some study, something is to come.
I am obliged.
According to you, there is nothing, and a blanket prohibition is not permissible. It offends the core value of those fundamental rights. And in Indian hotels and the restaurants, the Supreme Court has also taken that particular view and said that performance by way of a dance is a fundamental right. So you can't do it.
Form of expression. Form of expression. Well, my lord, kindly have a look for a moment that about fixation of CCTV cameras, the lordships has clearly said that it is to be fixed.
They have not spelled out. The chilling effect was thought of something which was kept hide by the apex court. It did not. That what could be, what could happen if the CCTV is there.
My lord, in green rooms, in dance stage, that is banned by Honorable Supreme Court. That is what I want to bring it to my lord's kind notice only. That's all. It's up to my lords to take a note of that. CCTV camera is always there. It is fixed in the entrance of the gate, and everybody who goes inside, who comes outside, it's taken up. The view is taken. Hard disk is there. They are free to take the hard disk and examine. But how can they compel the baron to fix it in the? That is.
We will consider that. We'll consider that.
For a moment, can I place that one paragraph of Justice retired K. Puttaswamy? That is that K. Puttaswamy. case Puttaswamy, that privacy, that nine years constitutional bench, that 2017 that landmark judgment where the lordships have held that the argument of the union government that by intervention of the court, privacy cannot be declared to be a fundamental right, which has been declared a fundamental right in 9 judge bench, constitutional bench, reported in 2017. Their lordships here in this 2019 Indian hotel cases, they have referred to that particular. May I place that for a moment only?
No, we are conscious.
Yes,
We have already.
because their lordships have held that they have quoted that in view of retired Justice K. Puttaswamy versus Union of India case, privacy has been declared the fundamental right. So you, for that reason alone, the privacy of the women cannot be destroyed, cannot be by putting CCTV cameras in their dance stage. That is what I am trying to. That is what I am trying to argue.
That we will consider. That what it means. The right to privacy means what?
Right to that.
We'll consider that moving around in a public place.
Yes.
Whether it contains a right to privacy is a too big a question one has to ponder upon.
That judgment is referred to.
We will consider that. What does it mean? Because I have
But I
judgment, but
I have prepared a short.
Please give it.
I'm giving copy to my friend. Deeply obliged to my lords for giving me so much opportunity.
One sentence.
Reply to a reply.
No, that is not. But one thing I forgot to mention, it is not submission. The Hotel Association case, Milord, there were 4 petitions, batch of read petitions under 32. Milord, these girls, Milord, which came, that is a registered society of bar girls. Milord, only the petitioner in read petition numbers 1 so is the Bharatiya Bar Girls Union, registered under the Trade Unions Act 1920. So locus I was raising. Your Lordship may kindly bear that.
I'm sorry, ma'am.
So their identity is known. Here, Milord, no identity. 4 persons are with.
There 500 girls wanted to come, could not come. Therefore, they registered it, and through their secretary or president they came. And here 4 girls have come. They are citizens of this country. They are citizens of this country. They have
Yes. One is a class action. One is an individual infringement or individual action. No difficulty.
Obliged. Obliged.
Yes. No, when you like to file the compilation.
Milord, by 14, Wednesday, by 14.
That was, the councils orally
Well, I have
made
already,
their submissions.
I have already solved copy of
Yes,
mine.
made the submissions, and a letter on submits that they may be permitted to file the short notes of the argument along with the decisions which they relied upon. Release the matter on 14th for such purposes. That's what, so you have to raise some of your mother. Single answer. How many mother matter? How many? 25.
ଫଟୋ ଭାଉଜଙ୍କ ପାଖକୁ ପଠେଇଦେବେ
New matters are all of the old matters.
ଆପଣ ମତେ ଯେତେବେଳେ ଆଡଭୋକେଟ ପଳେଇଲେ
Yes.
ବୁଝିଲେ ଆସୁନାହାନ୍ତି କାହିଁ କୋର୍ଟରେ କହୁଛନ୍ତି ସବୁ
Let that music be over so that
Your lordship's humor is of a very higher taste. I always, that I am deeply pleased.
And before your lordship rise, I had item number 20. I mean, the subject to your lordship's kind consideration, will it be taken up on Monday?
why? Why so hurry?
No, there is no hurry, my lord. We just wanted to know.
So we will continue. I think we have finished up to
Up to 11, I believe.
11. So definitely from 12 it will continue.
It will be great.
Monday. Yes.
Trace admission item number 1.
My
One,
lordship. Order dated 4/4/25. 4th April 2020.
Show us the arbitration agreement.
At page 99, my lord.
Yes, page
At page 99,
99.
my lord.
Hey, 99. Is a technical dispute or it is a dispute on non-payment? What?
non-payment.
Non-payment. So clause B would come.
Yes,
My
your
lord.
lordship.
So where is a section 21 notice?
Lordship at page 145.
Yes,
At page 145,
145.
my lordship.
This is not in conformity with the clause B because you have to name the arbitrator that appointed by you. And if they fail to appoint their arbitrator, then
one page 146,
yes,
and last line, on hearing from your end, the name of the arbitrator from our side shall be intimated.
so that is not the clause B. Clause B
And
say
also
that
we
you will
have-
appoint your arbitrator, they will appoint their arbitrator, and these two arbitrators will appoint the third.
And also,
So you'll have to nominate.
they are not responding, they are not responding to our.
Yes, what do you say?
communications.
Madam, why you are not? If they have raised a
Uh,
this is
you-
not a technical matter.
Yes, Your Lordship, on the last occasion in a similar matter, Your Lordship had appointed a sole arbitrator, Your Lordship.
No, we will, because there is, the nomination was there, you did not concur, so we appointed.
Yes, Your Lordship.
Clause B also says sole arbitrator or a panel of three
Three
arbitrators,
arbitrator. Yes,
one
Your
by
Lordship.
both sides.
I had sought instructions, yet they have not given me any instructions, Your Lordship. Your Lordship may pass any order. You didn't fit.
So the claim is of 33 lakhs.
Yes, Your Lordship, 33,70,000.
My lord.
So tell me, both of you,
Name and
tell me, give the list.
And lordship, serial number 12.
Give it to her.
Justice, Honorable Justice Mr. J.P. Das, Your Lordship.
Whatever. Both of you agrees. Serial number 12.
Yes, sir.
This was, what was the nature of the contract? What was the nature of the contract?
At page 14.
Yes,
At page 14.
at page
14. 1/4.
1/4. 1/4 is this is the supervision consultancy services for the work, construction of a cardiac care hospital, Jharsuguda on turnkey basis.
My lord.
This is what the contract is. Yes, pursuant to the advertisement issued for providing consultancy services for supervision works for construction of a cardiac care hospital at Jharsuguda on turnkey basis in the state of the Orissa. The petitioner offered his candidature and was emerged successful in the said bid. Stop. The work order was issued to the petitioner and an agreement was also entered into in this regard. After the completion of the work, the bills submitted by the petitioner is withheld, thereby raising a dispute with regard to the entitlement and or justification in payment of the aforesaid amount. the petitioner submitted the aforesaid bills to the competent authority and caused several letters in the form of reminders, several letters and the reminders to honor those bills, but there was no response at the end of the opposite parties. Ultimately, a notice under Section 21 of the Arbitration and Conciliation Act 1996 is served upon the opposite party, invoking the notice under Section 21 dated 10 July 2023, invoking the arbitration clause appearing in the said agreement. The terms and conditions contained in the said agreement includes an arbitration clause where the disputes. What is the page? 145,
Your Lordship.
Arbitration clause is at page
99.
99.
No, what I've said. Arbitration clause in paragraph 8.2.1, which is reproduced as under page 99. You just quoted 8.2.1. The manifest reading of the aforesaid arbitration clause indicates different parameters for appointment of an arbitrator in specific contingencies, in the specific eventualities. In relation to a dispute which is technical in nature, clause A thereof provides a complete mechanism for determination of such dispute through arbitral fora, whereas the other disputes have agreed to be determined by the sole arbitrator or agreed a sole arbitrator or the panel of the arbitrators, one of whom will be chosen by the party raising a dispute, other by the party against whom such dispute is raised, and the aforesaid two arbitrators would appoint a third arbitrator. The letter dated 10/7/2023, the letter dated 10/7/2023 in Visas, the dispute which is not technical in nature, and invited the attention of the opposite parties to appoint their sole arbitrator. But there is no response thereto. We are conscious that the arbitration agreement can be perceived not only from a separate agreement entered into by and between the parties in this regard, but also in the form of a clause within the general agreement in view of Section 7 of the said Act. since the parties have, the parties are not ad idem on the sole arbitrator, nor nominated their arbitrators within the time limited therein. There is no fetter on the part of the court to activate the provisions contained under Section 11 of the said Act. Since the validity of the agreement is not in dispute, and the claim is founded upon the non-payment of the amount for which the work has already been done, we find that such disputes comes within the purview of the arbitration agreement. Stop. The application is thus disposed of. The Honorable Justice Jyotindra Prasad Das is appointed as a sole arbitrator, who will enter reference immediately upon the communication of the instant order. The remuneration of the arbitrator is fixed as per the schedule appended to the said Act.
Item number 2.
May I please, Lordship, my lords? May I kindly see the order dated 2 May, my lords. And my lordships have directed for appointment already by consent by annexure. That is
No, on instruction. Now, what is the instruction, Mr.
for appointment?
Your Lordship, Ostama counsel will appear on
The
behalf.
principal employer is the opposite number 1.
One. Mr. Sonak Mishra, he is the counsel appearing.
Yes, he requested to obtain instruction. What is your instruction
for appointment?
You have already filed the counter affidavit and also.
Yeah, file a counter.
I'm just served a copy, but my lords.
Then you, if you like, because he has a right to file a counter.
But
you can't prevent. The copy has been served. If you like to file a rejoinder, then we can permit you.
I'll file a rejoinder, but on mutual consent, that was
whatever. The opposite party number 1 files counter affidavit to an application
just served today,
which is served upon the learned advocate appearing for the petitioner today. Stop. Liberty is granted to the petitioner to file rejoinder to the said counter affidavit within
2 weeks, my lords.
Within 2 weeks from 2 weeks, the holiday will intervene.
Oh.
Within 1 week after the opening of this court, following the long vacation. List the matter. 1 week after the reopening of this court.
Item 3.
3 and 4, same, my lord, similar.
He is appearing. Yeah, file counter.
2, 3, 4.
Same order.
Item number 5.
Pleasure.
Who is appearing in 5?
Item number 5, it was written Union Independence Party. We didn't receive the copy of this.
You have?
The Union Independence Party, we don't have, they didn't serve the copy of this.
But now madam has come. You are appearing for whom, madam?
My Lordship, I am appearing for the petitioner, Miss King Security Guard Service Private Limited.
I could not hear you, madam. What do you want? No, can you submit loudly?
My Lordship, I am audible?
A little bit, yes.
Yes, my Lordship. My Lordship, I am appearing in item number 5 for the petitioner, the Miss King Security Guards. It's a fresh petition, my Lordship.
Whatever they are appearing, you serve a copy on them.
Yes, my Lordship, we will serve it. My Lordship, the same matter is
1 week after the reopening. This is come 1 week after reopening.
My Lordship, the same matter is listed on 20th July, my Lordship.
What?
The same connected matter is pending, my lordship. The notice is issued and the matter is listed for 20th July, my lordship. So I'm requesting to connect the matters with them.
That I don't know whether it is a connected matter or not. 28th July, I do not know. So much of long time. Why long time?
20th July.
It's improbable. You come, we'll see on the day. Yes.
Item number 6.
1 week after.
My plea, your lords. This is, my lord, the arbitration clause is page 109, my lord.
Page
109, annexure 2, your lordships. The phrase.
You just type 109.
Annexure 2, my lord.
Where?
Your lordships, the clause 16 provides settlement of dispute, your lordships. 16A, your lord.
No, this is not 109. Yes, settlement, yes.
Then your lordship kindly 16A.
Just 1 minute.
Sorry, extremely sorry. 16A, your lordship. Next clause.
So this document is very cumbersome. I would say this scanning is very difficult.
This I will permit it to then move in hard copy. Your lordship, I have filed hard copy. I will file, my lord, illegible copy. This is the document of the MCL. We made a contract. This I will make type copy for legible if your lordship permit. I have no hesitation.
So there is a mechanism. Have
No,
you exhausted those?
Yes, my lord. The mechanism existed, my lord. Thereafter, my lord, I invoke the.
Serve the copy on the
This
other
is a
side.
base matter. Notice to issue.
Service notice 2 weeks after.
Register.
Item 7.
Obliged.
This is an application for appointment of arbitrator, my lord. And
Also, the Union of India Apache, we didn't receive the copy of this.
Please serve the copy. 2 weeks after vacation.
Obliged.
In the meantime, take instruction so that it's.
Obliged.
Item 8.
My lord, this is prayer for my lord, appointment of arbitrator, my lord.
Fresh.
Fresh, my lord.
Service 2 weeks. Affect the service notice.
Yes.
Sorry, here the term notice is used. Notice.
Item 9. Item number 9.
May I please, my lord? May I audible, my lord?
But not visible, sir.
Yes, my lord. It is a fresh admission, my lord. Notice.
Notice.
Item 10.
May I please, your lordship? In this case, the arbitration clause is at page 13.
Other side.
Yes, lordship. Today I filed my wakalat, my lordship. I need 4 weeks time to file my objection.
That's right. Yes. What's your good name, sir?
Sohan Misra. Sohan Misra.
Mr. Sohan Misra appears for the opposite party, then submits that he has filed the wakalatnama today.
Yes, lordship.
In the department.
Yes, lordship. In the counter, lordship.
Registry. In the registry. So his name may be whatever recorded in the constitutive whatever. Let the counter affidavit to the application be filed within 4 weeks from date.
Obliged, lordship.
2 days after the reopening. Do it. Enjoy the vacation.
Lordship, copy may be solved.
2 weeks after the the copy of do you have the copy?
I'll serve. In course of the day, I will serve.
The petitioner is directed to serve the copy of the application under section 11 of the Arbitration and Conciliation Act upon Mr. Misra in course of this day.
Yes.
Rejoin the counter affidavit 2-3 days after the reopening of this court following the long vacation. Rejoinder, if any, may be filed 1 week thereafter. List the matter in the first week of July.
Right. Item 11.
11 is also same.
Similar matter.
You are appearing.
Yes, Your Lordship, we have filed.
Mogalatnama file.
Yes, Your Lordship.
Same order.
Obliged. Obliged.
For orders item 12,
May I please your lordships? My lords, this is an dispose of arbitration application under section 11. That's an IE has been filed for extension of the arbitration period.
Can it be done? IA is sufficient. I think this was raised on the last occasion.
Yes, my lords. It came last on the last Friday. It was listed. Then the copy was served, my lords, on the other side.
So there was already an appointment of the arbitrator, but the arbitrator is not or refused or
No, my lords.
thereafter resigned.
No, my lords.
What could not be passed within the extended time?
Within the time period,
So you want an extension of time
my lords.
or what?
Yes, my lords.
Here, my lord, the division bench of this honorable court has laid down the law that under section 29A4, the party has to approach the district court
Why?
for extension. That is the law.
What? Let us see.
Relying upon judgment of the Honorable Apex Court.
Let us see. Justice Khanna's judgment. Let us see.
That judgment.
What is the judgment of the Supreme Court?
That is there, my lord. Page after the High Court's order, the Supreme Court's order.
Oh, this is section 11.
Yes.
This is section 11. Yes, yes. Then section 11, difficult situation. Extension of time. Actually, the mandate of the arbitrator that ceases. Then you'll have to go.
Let's say pray for a week's time, my lords. I will cross check and
After vacation, you come.
item 13.
I have to adjust myself because I have come from a court which has ordinary original civil jurisdiction. So there is no difficulty.
my obliged.
Yes.
Item 13.
May I please, your lords? Lord, I have also filed a application for recalling the 11 order, my lord. This error, my lord, from the that there is a violation of 11, section 11, subsection 13 of the Act, as well as read with 30A, my lord. 3A, my lord. Lord, the case before lordship that the statute provides when the courts feels that there is a sufficient notice, then he has to grant 30 days time. The second,
What do you say? Is the order recalling?
my learned friend virtual appearing.
Mr. Luradi is appearing virtually.
Milords, I'm Milord. For recall. Milords, I'm
Yes.
sorry, Milords. This was I was not told this matter would be taken up today. Milords, anyway, Milords, I have served notice today only at 1:30 p.m. This IA was served on me, Milords. Next Friday, can we fix, Milords? We can take it. Next Friday, can we fix, Milords? I can take it up, Milords.
On the prayer of the advocate appearing, learned advocate appearing for the opposite party, give his name. This is the matter immediately after the reopening.
Yes, yes, sir.
Item 14.
Milords, I am for the petitioner, Milords. Actually, I am for the petitioner, Milords.
I am for the opposite party.
You are the applicant of ISR.
Yes, your lordship. I am only
Yes.
Even the applicant.
Only difficulty, I may be the arbitral tribunal fixed for 17. I may permitted to move an application for adjournment.
We can't grant you. You go there and ask for.
Hello.
Yes. Much obliged. Much obliged. Much obliged. Much obliged.
Item 14.
Lords, this case your lordship will remember. The arbitrators are dead.
Oh.
So,
Your lordship, I'm appearing for the sole respondent in this matter, your lordship.
He said that he will be
audible, sir.
Lordship, I want to point out some points in this matter, Your Lordship. Your Lordship, the arbitration proceeding was going on. They file a writ petition against a counterclaim filed by us, Your Lordship. Then deliberately, they sat on that writ petition for 10 years, Your Lordship. In between, my party expires in 2021. In 22, their arbitrator expires in between. They had knowledge about this, the part that the arbitrator had expired, but he didn't came before the Honorable Court with clean hands, Your Lordship. They didn't mention this before the Honorable Court that the arbitrator has died. Just because this writ petition was pending, they took a liberty from this court, said that we will be raising all these questions before a new application. Now, Your Lordship, they come with the application under 11.6. Now, when the arbitrators have died, the clear definition comes under section 14, as Your Lordship had pointed out at the last occasion, Your Lordship. But under section 14, when the arbitrator have died, they should have moved an application under section 15, not under section 11.6, Your Lordship. These are the 2 points. Third point, the subject matter which has been in this issue before the arbitration proceeding is not in the hands of the legal hire, because the lease has gone out in 2020. The subject matter is not in the hands of lessee right now.
What lease has gone?
Your Lordship, he's a contractor who was working in my mining lease. In between, there was a dispute regarding the prime. So this arbitration was invoked in 2009, respectively. So, Your Lordship, the matter got hanged up since 2012. They made a false statement in their affidavit saying that the Honorable High Court had stayed the proceeding, but Honorable High Court never stayed the proceeding in 2012 writ petition 20,900 of 2012. This Honorable Court never stayed the proceeding. Your Lordship, the petitioner here in this 11.6, they should have proceeded with the arbitration proceeding.
The arbitral proceedings was there pending before the arbitration. The arbitrator died. That means the proceeding, what? The proceeding would remain in limbo or medio or to be considered as a dead one.
Your Lordship, they should have proceeded with the arbitration proceeding because they had only invoked.
If they do not, if they like a civil suit pending in the court, plaintiff not taking steps, matter remain pending for 24 years, does it extinguish the right? If we come after 24 years,
but Your Lordship,
the
petitioner never came with a clean hands, Your Lordship. They just deserted the arbitration proceeding. They filed this writ petition just to stall the proceedings. And they did
remain pending, sir.
Yes, sir. Yes, Your Lordship. The arbitration proceeding was pending. And they could have cared.
To talk about the abatement having not, then we'll have to think that the Court of Civil Procedure does not apply to arbitral proceeding. Whether the principle can be applicable, what can be done, you have to argue that whether we get principle akin to there too can be applied.
But Your Lordship, here before this 11.6, whether this provision is allowed under 11.6 to substitute an arbitrator. Your Lordship, when section 14 defines the de jure and the section 15 itself says that in addition
issue you are raising. That's you are asking a very basic question that section 11 cannot be invoked in such a situation. They have to take shelter under section 15. I appreciate it.
Lordship, yes, Lordship.
Sitting tight over the matter, writ petitions they did not pursue. Does it mean the proceeding will come to an end? The proceeding.
No, Your Lordship. But Your Lordship, see the conduct of the petitioner, Your Lordship. They never meant to have these proceedings going on. Suddenly they wake up after 10 years, after the decade.
That means the right is lost to continue with the proceeding. If the proceeding remain alive, I'm asking you.
No, Your Lordship. I'm not.
Does it mean that they were not pursuing for 10 years? So their right to pursue goes under the civil law. I do not know. I have to learn many things.
I bow down, Your Lordship. But Your Lordship, when they care about this case so much, at least they could have approached the court in a very minimum time, Your Lordship. But after waking up after the 10 years, they suddenly see the matter has been listed before this Honorable High Court. They just take a liberty and file this 11-6. So, Lordship, something has to be considered while accepting this 11-6, Your Lordship. Just seeing the conduct. Your Lordship, they did not have
He has
any conduct.
hijacked all your right of submission first. He has hijacked all your right.
That's the reason I've kept quiet.
Yes.
Your Lordship, the arbitrator expired in 2022. They come before Your Lordship in 24, and they do not define this condonation of delay. They have not filed this application. They
Is there-
just say we.
I am asking you, is there any limitation for making an application? Tell me.
Yes, sir. In Limitation Act, there is, Your
There is.
Lordship, 3
Show
years.
us which article of the Limitation Act applies and what?
So, Your Lordship, it is, I think, in 137 schedule, I think. Schedule 137, where it
Article
defines.
137.
Yes, Your Lordship.
Article 137.
That different. Lordship,
That's
I
the
have to go
residuary
through it,
article
but
you wanted to say. Is a
but
residuary you wanted to say?
Yes, Your Lordship, they should have explained the delay at least, Your Lordship, through an application. They're not filing any application after suddenly 2 years after. They
Law,
just.
I think law I have learned is that if somebody comes beyond the period of limitation, then he has to explain the delay that I have come. If somebody is within the period of limitation, is he required to give an explanation for delay? I am asking. First thing is there any period of limitation provided? If it is provided, whether he is within the period of limitation or beyond the period of limitation. If he is within the period of limitation, is it necessary for that litigant to give an explanation of delay? There is no delay. He is within period.
As Your Lordship.
And you talk about the residuary article, then it says the 3 years period when there is no period of limitation provided anywhere in the act or a schedule. Then in that event, 3 years from the date when the right to sue accrues. I do not know. The seniors are sitting, I do not know. I have to learn from them.
Your Lordship is right.
What
Lordship,
arguments?
these are the points I have to rest.
What arguments? Now tell me, he's saying that you have to take shelter under section 15.
No, Lords. Lordship, first come to Annexure 4, page 27. This is the writ application which was disposed of. Now, second paragraph, it starts, a memo has been filed to withdraw the writ application with liberty to raise all the points in dispute before the new.
Which one?
Page 27, paragraph 3. Annexure 4.
Yes, you wanted to withdraw.
Yes, thereafter, Lordship, paragraph 3. A memo has been filed to withdraw the writ application.
No, I've seen.
Yes, before the newly appointed arbitral tribunal yet to be formed. Now he was present. Mr. L. Mahapatra, learned counsel for opposite party, appears through virtual mode and submit. He has no objection. He did not raise any objection.
Then
the matter was disposed of. Then your Lordship may kindly turn to Annexure 5. This is a letter requesting for appointment of arbitrator. This is a letter where I, at page 29, suggested my arbitrator to be Justice R. Bhanumati, retired, Judge of the Honorable Supreme Court, as our arbitrator.
In relation to a dispute which arose when
Dispute arose in 2022.
The cause of action.
Cause of action was 2002.
2009.
Section 21.
Lords.
Now this cause of action arose when?
2009, Your Lordship.
This letter was issued.
When dispute arose.
This yes, he did not reply to my.
When the dispute means
that
dispute which is arbitrable.
Yes, yes, I'm coming to that. That is the dispute agreement is of 2005, and the notice of given for appointment is
If it is considered to be a fresh notice under section 21 of the Arbitration and Conciliation Act, then the period of limitation one has to consider.
That continues, my lords, because
Is a recurring one. The dispute was a recurring one, or
there was a stay order by the High Court.
No, Your Lordship. I object to this statement, Your Lordship.
The stay was what?
Issue notice on the above. This is still the next state. The prayer for further proceeding in ARBP 1 of 2012 is stayed. So I was
arbitral proceeding stayed.
Yes.
In 2012.
Yes.
Writ petition entertained.
Yes. I filed a writ application. This is the order. Your Lordship may kindly see the order.
Have you read the SBP Limited versus Patel Engineering?
Five judgments.
2005. I think volume 6 or 7 SCC.
There was a dispute. There was an order.
Clear mandate that no order of the tribunal is amenable to be challenged under Article 226 and 227 of the Constitution. If somebody is aggrieved, he can take that plea under Section 34.
Yes, that judgment, that this is an order which the arbitral tribunal passed, and I
was it an order under Section 17?
It's Section.
It was not a interim order under Section 17, which is applicable under Section 37. It's not an order.
But wrongly or rightly, I was protected under the order of the High Court. And thereafter, I issued the notice that they did not reply to that notice. So they have waived their right for appointment of their arbitrator. Now, an arbitrator has to be appointed, and our arbitrator and their arbitrator has to appoint the presiding arbitrator.
What is the latest one? I am out of touch for many years. What is the latest one?
Latest is Bombay High Court. This is 2016.
Give me the apex court judgment, because most of the judgments is authored by Justice Nariman during his.
Justice Nariman judgment is also there, but I will take your lordship.
I think the Ashoka Builders or Ashoka Traders, what is that judgment?
The judgment is in the meantime, I will check. Your lordship have come to paragraph 2. This is an application under 11.6 of the Arbitration and Conciliation.
No, question is not that, sir. There was already an appointment of an arbitrator.
Correct.
The arbitrator entered into a reference.
Correct.
The matter was pending. There has been a stay of all further proceedings in the pending before the arbitral tribunal. Now, arbitral tribunal could not proceed because of the stay. By the time the stay was lifted, it appears that the arbitrator is no longer, he died. Now the question is that whether it invites a fresh application under Section 11, or it can be taken under other provisions of the Arbitration and Conciliation Act. This is the only thing. If it is under Section 11, then show us which provision is activated. if you raises a fresh demand,
I am not raising a fresh demand.
again I'm saying, then you'll have to show that under what provision of section 11 you can invoke. Tell us straight away. If you raises a fresh demand, then the question of limitation will come, whether it is a scale claim or it is still within the, yes. If you say continuation, then you'll have to show. The arbitral proceeding is still continuing, but because of this mandate has been terminated, it will revive. Show us. If it is in that situation, no difficulty. It's really a continuance of that. But if it is a fresh demand under section 21, then
now, because if your lordship,
very difficult situation, sir.
If your lordship may see the letter which I have issued for appointment of arbitrator, there I have not raised any fresh cause of action. These are
which is the proper forum?
Proper forum will be 11.6, Lord.
Show us 11.6 language.
This is the judgment which I have given. Let me read it out.
No, just show us 11.6.
11.6.
Please.
So there is no speaking on 11.6, but (6)(b), the parties of the two appointed arbitrators fail to reach an agreement expected of them under that procedure.
This is not a case, because it was a case of a sole arbitrator and he died.
Not getting it in section, but your lordship, if your lordship may kindly see the judgment of the Supreme Court, where 11.6 has been read along with 15.2.
Show us. Yes. The 15.2 has to be harmonized.
With 11.6.
Not 11.6 in that sense. Where is the judgment of the Supreme Court?
That I have. Paragraph 8. May I read the entire judgment?
No, it's not.
Clause 22.3 of the supply contract contemplates appointment of a sole arbitrator by the parties by mutual consent in a situation where the original arbitrator has recused himself and substitute or a new arbitrator is required to be appointed according to the rules that were applicable to the appointment of original arbitrator. This is the mandate of giving notice and explore the possibility of naming an arbitrator of mutual consent, and only on failure thereof the present application under 11.6 of the Act would have been filed. Here I gave a notice, they kept quiet. I gave a notice to the arbitrator who was there, he kept quiet. And there is one.
Just
one. Sorry.
Yes, yes.
And that Justice Nariman's judgment is Shailesh Hairavan.
Show me.
Huh? Right. Paragraph, page 12.
Page?
Page 12, internal page 12, paragraph 13.
This Yashvit constructions have also been considered.
Yes, yes, that judgment I have. May I hand over the judgment? This is harmonious construction.
Yes, yes, any judgment, you just give it to me. I will take care of this. You just send it.
Should I make a citation and make a citation of the judgment and I can hand it over tomorrow?
Give it. Tomorrow?
I may be allowed to submit some notes.
Yes,
Your Lordship.
on next Thursday. List it on next Thursday. Not, I will have a sit on Thursday, not on Friday.
Because Friday there will be up.
Yes, I have a.
My lord, may I make item number 23? Both of us agree for arbitrator.
To come on next Thursday, agreed upon, give that.
Leftover matter.
On next.